Okay, we're on the record in the matter of the people of the state of Michigan versus John Kane and file number 23-00238FY.
Thank you, Honor. Call charter.
And please, the court, David B. Carter Jr. on behalf of Mr. Kane, who is not present, but it's my understanding he is appearing on Zoom.
I can't see him. Okay, my order said he must appear in person.
I did check my file. My client indicated to me that his notice indicated that it was to appear by Zoom. I checked my file and my file indicates in person. I explained that to him.
Yeah, we don't print separate ones for Zoom, and we just print one and he gets a copy.
I totally understand that. That's why I checked my file to make sure what mine said, and it indicated it was in person. I don't know why he thought it was in Zoom. I can say
I don't know
that
either. And he set for a PA 53 contempt.
I have an officer here, Your Honor, but in talking to the court staff, and it sounds like that PA 53 precedes his plea. So wasn't sure if that was still on the table or not. I do have an officer here.
PA 53, I believe, was wrapped up at the plea. However, there was a bench warrant issued because he failed to do his PSI or contact probation after he was released from jail. And looking at the file, I think maybe that was perhaps what the PA 53 was concerning, was his failure to follow through, because there's been no new conduct since his plea, except the fact that he did not meet with the PSI people.
I have, it was plead guilty to count 2 of domestic violence, dismiss count 1, and sentence enhancement. There's nothing about a PA 53, and that can't be a part of an offer anyways. It's a contempt of court order. Prosecutor doesn't have control over that. So, and I don't have a plea sheet otherwise, so he was set for a hearing today. Either way, he was supposed to be here in person, and he's not here. What time is he gonna get here?
He's in Petoskey.
Well, that's, I'll issue a bench
He
warrant.
is, according to my client, as I was talking to him, he's at Petoskey waiting for a bed to be available for Bear River.
Bear River will come get you from anywhere.
I'm just directing the.
Mr. Kane,
Yes,
we need to see your face.
I can't hear on the phone.
You were supposed to be here in person anyways.
The sentencing hearing that I'd gotten, the paperwork I was given at the date of the plea was to appear via Zoom and given Zoom instructions for this hearing. It was for sentencing.
Let me
for
see.
plea
Let me see the paperwork that says that.
I don't have that currently.
I'm sure you don't, because I have the paperwork that we sent you, and it says must appear in person.
Why would I have been given Zoom and from the plea agreement? You guys gave me Zoom instructions.
You were supposed to be here for a sentencing originally on July 15th. That probably you had Zoom instructions for, but you did not follow the court's order as it related to getting your PSI completed. So your matter was reset for sentencing on July 15th to today, and I reset your bond, and I ordered you to appear in person, and you were not allowed to appear via Zoom. You also have a contempt of court hearing scheduled for today, and we have an officer present today for that contempt of court hearing.
I didn't know there was a contempt of court hearing scheduled for today. When I knew it was the 27th, July 27th, 8:30 a.m.
You were arraigned and provided notice of that, sir.
No, it said the court would be in contact. I left my phone number and somebody would be calling me because I didn't have an address for anything to be sent. That paper, I do know where it's at.
Did you provide the court with the new address or whatever address you're staying at in Petoskey?
No, I just got up here 2 days ago.
Oh, okay. Well, then that was your responsibility to provide the court with an address.
But they told me
But
to grab this
either
other.
way, you were provided a notice to appear in person for your sentencing, because you were here when I told you to appear in person for sentencing. Your attorney has a notice that you are supposed to appear in person. Your attorney is here in person. You are not.
I'm trying to
I'm going to
get
issue
my
a bench warrant
Oh, yeah.
for failure to appear in person like you were ordered to do.
Where is it? Where did it go? I'm digging for this other court paper, like, because they gave it to me over at the jail, and it said that it would be.
That was different. I arranged you a couple weeks ago on the weekend for something different, sir.
No, that's the paper I had was from that arraignment. Was they said you don't have an address, they'll call you.
Correct, but
And
you were
that's what I
giving
was
your
instructed by the
sentence
jail.
date. You were not giving your sentence date at that arraignment. You were giving your sentence date on this matter back on June 1st.
It even shows online that today was sentencing for the original plea agreement.
I don't care what it says online. You're supposed to be here in person. Are you not understanding that?
Well, I get what you're saying, but
Oh.
I was given the paperwork I had said appear in Zoom for sentencing for today, and when I left the jail, they said they would be calling me because I didn't have an address for them. Not able to physically receive mail. And it says right on that paper that they gave me to be determined.
I'm resetting it. You need to appear in person.
Okay, when? So that way I can go sit in jail for the jail's miscommunication.
August 10th at 9:30.
August 10th at 9:30.
August 10th, 9:30 in person.
If you're in person, if you're confused, you should call your attorney. That's why you have one.
Actually, I didn't even have his contact information.
Well, that's not the court's problem. He's been representing you for quite some time, so you should have his contact information.
I didn't even have a card or anything when I left the jail from that original, from the plea agreement.
Any additional matters for the record?
No, Your Honor.
Not from the people, Your Honor.
We'll see.
Your Honor, if
Yes.
you could ask Mr. Kane of his phone number, please.
Mr. Kane, what's your phone number?
Give me just a second. I gotta go look. If I can get the phone to cooperate. Oh, work, you stupid thing. Four 517-429-9377.
Thank you.
Do you need his address? What's your address?
Hang on.
Just tell me the hotel you're in Petoskey. I can follow through from there.
Do you know, are you at a hotel, sir?
Yes, 1 second. I'm trying to get you the address.
Just tell us the name of the hotel. What's the name
It's
of
the
the
Michigan
hotel?
Inn and Lodge. Michigan Inn and Lodge.
Thank you. Okay. We'll see you on your next court date in person.
Okay, so there's still a bench warrant being issued or no?
Nope, I reset it.
Thank you, Your Honor.
Okay.
You're welcome. You're free to go. On the record, in the matter of the people of the state of Michigan versus Leasia Armistead, File number 21-02870FY. Appearance, please.
Good morning, Your Honor, and everyone here attorney for Asia. She's by my side.
Okay. Today's the date set for sentencing. I do have a pre-sentence report. It was prepared on July 13th. Did you get a copy of that?
I did, Your Honor.
Okay. Do we need to make corrections, updates, or deletions?
Just the fact that my client, some little corrections, the fact that my client is employed at this time.
Oh, where are you employed, ma'am?
It's called ASAP. It's an off plan for GM.
Any additional updates, corrections, or deletions?
I know, Your Honor, thank you.
Okay, you can make allocution.
Well, Your Honor, I think that since we were here, my client has made some progress to show this court that she will resolve all the problems that led to the contact with the criminal justice. She has an employment, she's employed at this time, and she's looking for a job. And because she's employed, I think that it's a great way for her to have housing. She's planning to renew her marijuana card. She said that she's using the marijuana because of her ADHD and also bipolar, and it was helping her better than the medication that she used to take. So she's now that she's employed, that was also the reason why the card was not renewed. She didn't have money. So she's planning to do that today when she lives here. She's looking forward to taking care of her daughter. She has a 6-year-old daughter, and she has always been a good mom. She's looking for a home, and she's planning not to allow anyone which is not a great person around her daughter, because I think that she realized that that was something that she lacked in the previously. She has the support of her sister. Her sister has always been here in court, supporting her, driving her around, and we will ask the court to follow the recommendation to grant her the 7411. She told me that regarding the substance abuse assessment, she did that with Crystal Ray. Crystal Ray had said that they were going to email that to her probation officer. So she was under the understanding that the assessment has been sent to the probation officer.
Okay, well, as of the date of this report, probation had not received it. Did you sign a release for them to send it over?
Yeah, they had me sign this paper and they said they're gonna email it to the probation.
Okay, and they may have received it since the date of this and just didn't provide an update. I do know Ms. Duhosky was on vacation, so she may not have had time to do an update. Either way, you can always address that while on probation. It looks like you did do it. So any additional allocution, or did your client want to make a statement?
I know nothing on my front.
Okay. Okay, Ms. Armistead. It's been a long time coming to get to the sentencing date. You had a lot of things going on at one time. However, consistently showed yourself to the court when you were supposed to be there, except for that period when there was the bench warrant status, maybe due to change of address. But nonetheless, you've been here, you've followed the court's orders to the best of my knowledge. The recommendation that I have from probation is that you do score moderate to high risk in some categories, and so some probation services would be beneficial. One of those high risk areas would have been needs in family relationship domains and companions domains and leisure activities, which that leisure activities might be addressed by the fact that you're working. You may not have the same needs for leisure activities other than rest.
Yeah, I'm tired right now.
Right, it's so that could address those things. And then you have a child, so maybe some programming can help you with addressing the family relationships domain. I do see here that you were pretty close to finishing high school, but you didn't. Okay, you don't have a desire to
Yeah,
complete that?
I was just trying to
Get
get my
back on
head
track?
calm so I can focus. With all the core stuff to move it kind of hard.
Got it. And you're looking for housing?
Yeah.
You reported having concerns about financial obligations of probation in your housing. What is the concern?
Well, I have a job now, so.
Okay, so when you did this, you didn't have the
Yeah,
job. Got it. That makes sense. Okay, this is your first conviction, according to our records, and so you would be eligible for special status under 7411. There was no objection to 7411 at the time of sentencing, and so I will put you on a term of probation and grant you 7411. To be placed on a 12-month term of probation. While on probation, you're not to engage in any assaultive or threatening behavior, and you're not to purchase or possess firearms, ammunition, or weapons of any kind. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance without a valid prescription, okay? Once you provide us proof of your active medical marijuana card, you just need to give a copy. Then we can amend this to allow you to have that, okay?
Yes, ma'am.
You're not to be at any bars or nightclubs during probation. While on probation, you're required to submit to random preliminary breath testing and or urinalysis testing. You would be responsible for the cost of that, okay?
Yes, ma'am.
I am going to order that you enroll in a GED or high school diploma program to complete your remaining credits, okay?
Yes, ma'am.
Because we don't have the assessment back from Crystal Ray to tailor what you need, I'm just gonna put here that you will provide your assessment to the extent that it hasn't been provided. And then you will follow all recommendations of probation as it relates to whatever treatment you may need, okay?
Yes, ma'am.
Do you have any questions at this time?
Oh, ma'am.
You're required to maintain your employment while on probation, and you'll provide evidence of that to the probation department. As to fines and costs, there is a $30 per month oversight fee that you're responsible for while on probation. There's a statutory $75 crime victim rights fee that you're responsible for, plus a $50 state minimum cost. I'm gonna waive discretionary fines and costs. I don't see it. Go to black. God bless you. I don't see where cost recovery was ordered in this offense. And the total fines and costs is $485, but you'll make monthly payments on that I know you're just getting the job, you're just getting on your feet. It's about $40 per month, but right now, while you're getting on your feet, you should be prioritizing that money needed for whatever testing you're ordered to do and getting enrolled in testing and completing that. And then any money that you may need for programming or assessments that may need to happen. And we can take care of that $485 at the end if you're compliant with everything else. I'm not going to give you a violation for not paying those fines and costs, but I would violate you for doing anything else. Do you understand that?
Yes, ma'am.
Okay. Do you have any questions at this time? Okay. This is an advice and price as it relates to probation and when and how you can request early discharge. Need you to read that over and let me know if you have any questions. You have any questions? Okay, when you leave here, you should check in with probation. You primarily want to make sure they have accurate contact information for you, but you also want to make sure you don't need to do anything else to get that assessment sent over to them, okay?
Yes, ma'am.
And then you'll be free to go for today. They'll be in contact with you after this is drafted into a form for you to review, so that you can review the order of the court and sign it, okay? Any additional matters for the record today? All right, good luck to you, ma'am. Thank you. You're welcome. On the record in the matter of the people of the state of Michigan versus Ricky Evans, file number 23-00897. Council appearance.
Your Honor, Dale Coltrane on behalf of the people.
Mr. Evans, how are you? I'm well. Did you get an attorney? Okay, well, what's your plan, sir?
Jared Austin said I can try it one more time, but I think I was just about to represent myself.
You can try to get a court-appointed counsel again?
Yes.
Okay, you believe your financial status hasn't changed such that that decision would change?
I mean, it was the same as the first time, but somehow it's not, they declined second. So it's like,
Yeah, that's weird, isn't it?
yeah. Bothers me.
Yeah, well, I think it's worth trying again.
I could try it one more time.
We have the chief prosecutor here. He might be able to answer some questions.
Your Honor, good morning. My name is Keith Watson. I am the public defender. I'll be very
I'm
pleased.
sorry,
to
chief
speak
public
with
defender, I
this,
said prosecutor.
with this young man right in the hallway today to try to get a handle as to where in the appeal process he may be, so I can get a clearer picture from our support staff that conducts this.
Okay, yes, he was originally appointed public defense counsel and then he hired an attorney, but I guess he wasn't able to make those payments, so that attorney withdrew. And then when he reapplied, he said his financial situation didn't change, but
I'm unclear, Your Honor. I'm sure Your Honor is well aware that we have many people who are being screened on a regular basis and who are also in a position where if there's a denial, if there's an appeal process that we follow, we have a protocol that we follow regularly. We're very, very pleased to speak with him as soon as Your Honor is on the record, so that I can get that started and then get a handle.
okay, did you want to take an opportunity to do that?
Yes.
Okay, so then we'll reset this so that you can have an opportunity to reach out and get more information. You reported back in March, you were self-employed?
Yes.
Okay, you were on probation at the time?
Yes.
You're still on probation?
Yes.
Okay. Let me get in the date.
August 10th at 10.
August 10th at 10 a.m. get you a copy of that notice to appear, and then you can meet with the public defender's office today. You're in luck today because we have not only the chief public defender, but we got his deputy and at least 3 others in here. So I think you can get your questions answered today, okay? That too. Okay, you can have a seat
Just
there.
called you old.
That's right, that's the only part.
You have a seat, we'll get you a copy of your notice to appear.
Young man. Thank you, Your Honor.
Thank you. Okay, I hear we're running Beasley. Is that correct?
Yes, ma'am.
Did I see Mr. Dwight here?
He's here.
I gotta go check something. I see. We're on the record in the matter of the people of the state of Michigan versus Cornell Beasley, file number 23-02119. Counsel.
Thank you, Your Honor. Dale Coltrane on behalf of the people.
Attorney Luke Goodrich from the Public Defender's Office, co-counsel for Mr. Beasley.
And Assistant Public Defender John Lee, co-counsel for Mr. Beasley as well.
Okay, today is the date and the time that's set for a preliminary examination. My understanding is that there was previously an offer extended, but now the parties are seeking to waive the timeline. Is that correct?
Correct, Your Honor. Yes, Your Honor.
Okay, and so, Mr. Beasley, you understand that you have the right to have a preliminary examination within 21 days of your arraignment.
Yes, ma'am.
Okay, so your matter was scheduled for exam today. You were originally arraigned on July 10th. Are you willing to waive the timeline in order for you to get this matter reset?
Yes, ma'am.
What's the purpose of the waiver? Just more time?
I think 2 weeks, Your Honor.
Oh, I just want to know what was the need for, why do we need more time?
The people, he has a prior conviction, and unfortunately, it's so old that it's in deep storage. It's not online. So we've been notified they're going to need another week, late next week, before they can get that out, copy it, get it to our office.
Got it.
We have a certified copy.
Okay. Is anybody threatening you or forcing you to get you to wait the timeline?
No, ma'am.
Okay, we'll get you a new date.
August 25th at 9.
August 25th at 9 a.m.
Thank you.
No problem. Do you have any questions today?
No, I don't.
Are you related to a Darshell Beasley? Oh, you're not? Okay, just wondering. Any additional matters for the record today?
Not from the people, Your Honor. Nothing for the defense, Your Honor.
Okay, bond will continue. We'll see you on August 25th.
Thank you.
All right, thank you.
You're welcome. Okay. Mr. Carter, what are we doing?
We're ready to proceed on that 300.
Okay, I need to put something on the record first, on your case. On the record, in the matter of the people of the state of Michigan versus Brian James Joy, file number is 23-01836. Counsel appearance. Who's the prosecutor on that? Is that not you? Okay,
Oh, Brian Dwight?
yes.
Sorry.
Counsel appearance.
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
Thank you.
May it please the court, David D. Carter Jr. on behalf of Mr. Joy, who is present sitting at council table.
Okay, and I don't know if you were all ready to go or not. I just wanted to put on the record that it occurred to me today when I read his name was familiar. I did represent Mr. Joy back in 2013. It's well beyond the 3-year time frame, but I wanted to put that on the record to the extent there was any concerns.
No concerns from the people, Your Honor.
I wouldn't think so, but I'd like to inquire. with my client.
No problem. I didn't even remember that's BCC.
He's telling me no. So
Okay, sounds good. Any additional matters before, if you're ready to go now, we can. If you need time, we can.
People are prepared.
Are you prepared to go now? Okay, wonderful. Any preliminary matters before we proceed?
Your Honor, I do have one matter that I'll be addressing during the witness's testimony as well. Miss Chelsea Doig is one of the victims in this matter. The other matter, or the other victim, my apologies, I need a little more coffee today. The other victim is a minor child, her minor child who was subpoenaed. She did not bring the minor child today. I asked her if she understood it was a court order that she bring the child, that it was not necessarily a choice that she was making to bring him or to not to bring him. She stated that she understood that and she still was unwilling to bring him to court. So I'll be addressing that a little later on.
Any other preliminary matters?
Not from the people.
none for the defense.
Okay, you can call your first witness.
Thank you, Your Honor. I let the prosecutor know you're here. You should be out soon, okay? You can actually go right on left to go to the witness stand, okay?
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you can put your things there, and I also need you to speak up because your voice is a little light, and she needs to be able to pick it up on the speaker, okay?
Okay.
Thank you. You can have a seat. We have a microphone that's in front of you. Again, that's my court recorder sitting behind you. She has to take down everything being stated here in the courtroom, so your responses should be, they need to be loud and clear. They need to be verbal. We can't do head nods or shakes or uhs and ahs, okay?
Okay.
And then if there's an objection from either of the attorneys, you would stop speaking. I'll make a ruling on that objection, and then I'll tell you if you can give that answer or not. Can you first state your first and last name and spell both of them?
Chelsea Doig, Chelseaa, Doig, Doig.
Okay, you can proceed, counsel.
Thank you, Your Honor. Ms. Doig, it's my understanding that you're still fairly recently married. Is that correct?
That's almost a year.
What's your maiden name?
Maiden name is Garza, Garza.
And Ms. Doig, how many children do you have?
4.
And can you give me their names and dates of birth?
Julian is Julian. Last name is Mejias, Mejias. Yes.
Okay. And your next youngest child?
Ezra, Ezra, Mejias, Mejis. He's 11.
Okay.
Lorenzo, LorenzO, Mejias, Mejis. He is 7.
And then you have a baby, right?
Kaden, Kayden, Doig, Doig.
I'm bad at math. He was born in
November.
November. Okay, thank you. Do you have any stepchildren?
I do.
And what are their names?
Braden Doig, Brayden. He is 7.
Is that the only child? There was a police report written and it said that there was a 10-year-old boy home. Would they have been mistaken if they wrote that?
Ezra would have been 10 at the time. He is now 11.
Oh, okay. The police report says that that was Brian's child, so that would just be an error in the report.
Correct.
Okay, thank you so much for clarifying. And Ms. Doig, do you still live at 4316 Devonshire? Did you live there on February 1st of 2023?
Yes.
Who did you live there with?
My husband, Brian Dwight, and our 5 children.
And on February 1st, 2023, did you have contact with police?
Yes.
And can you tell me why that contact occurred?
My son had called the police.
Do you know which son that was?
It was my son.
Okay, so you believe Ezra was the one who called? And when the police arrived, where were you?
At my house.
And what did you tell the police when they got there?
I mean, I can tell you, yeah, the police report.
I understand, but the police report's not a part of this record, so I need you to answer the questions, please.
I guess I object in the form of the question. What did she say? I think she needs more foundation because I have no idea if it's going to be hearsay. I don't know how to object if she's asking her to just create a narrative form. I'd ask her to break up her questions.
Can you repeat your question?
I asked what she told the police when they arrived.
what she told us? How could that be hearsay?
Again, it's hard for me to
Okay,
determine what she's going to say.
Well, let's let her see it,
I
and
told
then
the
if they-
police that such and such said this.
then you can object if she says that.
Okay,
What else?
it's such a narrative thing, and what did you tell the police? I guess, is it the very first contact? Seems like a very loaded question.
Well, I'll allow her to respond. There's no objection at this point.
Well, I can tell you what I told the police was incorrect, so I can tell you the story of exactly what happened.
Can you tell me what you told the police?
It was a while ago. I can't tell you word for word exactly what happened, as there was a lot of adrenaline and commotion going on that day.
Would reviewing the statement in the police report refresh your memory as to what you said?
If you want to say a statement, then I can tell you if it was true or not. Like I said, I exaggerated the story and I did not tell the correct story to the police.
Did you tell the police that Julian had eaten a popsicle that was not for him?
He had eaten a popsicle, yes, without asking.
Okay, and that upset Brian?
It upset both of us. It wasn't just for me. And it was just the fact that he did not ask.
Okay. And at that point, did Brian yell at Julian, tell him he needed to go to the store and buy more popsicles?
There was no yelling. There was a discussion in regards to replacing the ice cream.
Okay, so did Brian tell him he needed to go to the Quality area and buy more?
No, we had said that he was to use his money in regards to replacing the ice cream that was left for someone in the family who did not get one, because there was only 6 at that time.
At some point, did you hear a dog gate being thrown down the stairs?
Not being thrown, but I heard some commotion by our basement.
Did you go see what the commotion was?
After the fact, I was in the room trying to feed our baby at the time.
Did you go towards the location of the noise that you heard?
Yes.
And what did you see when you got there?
I was at the top of the stairs and I just seen my son Brian at the bottom of the stairs talking.
They were talking?
At that time, yes.
So at any point, did you see Brian on top of Julian?
Not at that time, no.
If you told the police that you saw Brian on top of Julian, that would have been a false statement?
No. I said not at that time.
At some point, did you see Brian on top of Julian?
I wouldn't say on top of him, but there was, I guess, an altercation type.
Can you describe the altercation for me?
From what I can remember, my son, there's a story before that. I can't just give you the altercation while jumping a whole bunch of the story.
Okay, I need you to just answer the questions, please. Can you please describe the altercation?
My son had Brian's balls in his hand while Brian was trying to get away. He was not able to until my son released his balls, and then they were able to stop the confrontation.
Did you see what happened immediately prior to Julian grabbing Brian's testicles? So tell me what happened between the time that you saw them having a verbal argument at the end of the stairs to the time that you saw Julian grab Brian.
Well, there was no verbal argument at that time when I was at the top of the stairs. They were just talking.
Okay, tell me what happened from the time you saw them talking to the time you saw Julian grab Brian.
I had came downstairs and I had our 8 and 7 month old, well, 2 month old in my hands at that time. Brian was trying to walk away from me. I started hitting him from behind. things are a little fuzzy after that, but in that case, and then the next thing I know, my son attacked Brian from behind and grabbed his balls. I guess landed on the couch.
What caused you to start, I apologize, I'm forgetting the words that you used. What caused you to start engaging with Brian physically?
At that point, I was going through severe postpartum depression. I was having some issues. I had just got on some medication about a week and a half before that. I was angry and mad. I felt like I needed help and he was not there helping me. There was some cheating allegations prior to this. So again, I was depressed and that did not help the situation and I wanted to hurt him.
At any point prior to you touching Brian, did Brian touch you?
No. He did turn around, but he did notice the baby was in my hand and he walked away and held it.
So if you had told the police that Brian reached up and grabbed you by your face and pushed you back, would that be incorrect?
It would be incorrect.
Did you tell one of your children to call the police?
I did.
So if you told the police that you had instructed one of your children to call 911, that would also be incorrect?
Correct. I had already knew he was starting to call at that time when I had went into the room to put my 2-month-old down on the bed with my 10-year-old son.
At what point did the children leave the home?
Situation calmed down.
Why did they leave the home after things had calmed down?
I had told them to go wait outside.
Okay. And why did you say that?
Because I did not want to see them in the state that I was in.
So that would have been when Julian and Ezra left the house, is that right?
I told them to go sit outside.
Okay. Did you attempt to leave the home at that point?
I went outside.
And did Brian follow you?
Not immediately, no.
Did he at some point come outside with you or follow you?
He came outside at one point.
Did he have your phone?
I think at one point, yeah.
Was he going through your phone?
I don't know.
Did Brian throw your phone at you?
No.
So at no point did the phone get thrown at you and strike your body?
No.
So if you told the police that Brian threw your phone and it struck you in the lower back area, that would be an incorrect statement? Is that a yes?
Yes.
At that point, did Brian leave the home? Did Julian tell you that he was in any pain or had any injuries after all of this had occurred?
No.
Did you take Julian to see any doctors or not an emergency room, an urgent care or anything?
No.
Okay. Did you go to an urgent care?
No.
And so is it fair to say that you didn't believe you had any injuries either?
Correct.
What about the baby, Caden? Did he have any injury?
No.
Okay. After this incident occurred in February, is Brian still residing at 4316 Devonshire Avenue with you and your children? Have you and Brian discussed what happened on February 1st at all together?
We haven't prior, yeah.
And what did Mr. Dwight tell you about this incident?
I would have to leave that question.
No,
Because you have to answer
it,
the
please.
question, you're under oath.
He told me his side of the story, stuff that I may not have seen at that time.
Can you help me understand what his side of the story was?
I can't tell you exactly, honestly. I mean, this was back in February when we talked about it.
So you talked about this incident right after it had occurred? Did that happen while Mr. Dwight was incarcerated?
No,
It happened once he was released,
before.
so he was incarcerated.
No, he was not incarcerated immediately after the incident.
Okay, so you talked to him before he had any court involvement on the case? Okay, thank you for correcting me. And you don't recall anything about his version of how this all went?
It's similar to mine. I mean, there are some other details that were said in regards to when I was not with Julian, when I was in the room feeding the baby.
Okay, can you tell me about what you were informed of about that time?
When he went downstairs to speak with Julian in regards, my son had pulled out his airsoft gun onto Brian. And I believe that's where their discussion had furthered, and I had came down and I did not know about that at that time.
Did you ever see the airsoft gun sitting out in the open?
Yes, I did. My son, it was next to my son when I went downstairs, but I did not think anything of it at that time.
Where was the airsoft gun usually kept?
My son had just got it for Christmas. It was in his room.
Okay.
It was technically at my parents' house. I did not know that he had it until the day prior.
Okay.
He had stuck it home without my knowledge.
And did the airsoft gun stay where it was up until the point that the police arrived, or did it get moved? Okay. You never moved it?
No.
Okay. And so where in the house would that have been at the time that the police were there? Any more specific than that?
I do know my son was demanding to get paid.
Okay, I'm just asking more specific as to the location. I apologize, it was a bad question. Okay. Would it have been right at the bottom of the stairs where they were talking?
Yeah.
Are you aware if Julian talked to the police that night? Were you present for that? How was Julian acting at that time?
He was calm. He wasn't crying. I think he was just a little bit nervous.
Did you and Mr. Dwight ever discuss why he left the home prior to the police arriving? Have you discussed that since this time?
We haven't really discussed the situation at all.
Okay. Except for when, like right after it happened? Oh. At the time that this occurred, was there any type of no contact order or protective order in place between you and Mr. Dwight?
No.
He was on probation though, correct?
Yes.
And are you familiar with the terms of his probation?
Yes.
And what are some of those terms?
He drops twice a week. Weapons in the house, drinking, drugs. He reports to his probation officer.
Any other terms that you're familiar with?
I mean, that's the top of my head. These are the main ones that we focus on.
Okay. Had Brian had anything to drink or any intoxicating substances this day?
No.
Chelsea, can you help me understand why your story to the police on the night of versus today here in court is different?
Absolutely. Well, like I stated before, I was in severe postpartum depression. I kept asking Brian for help. He didn't know how to get back to me. I was hurting. There were some things that I had found in regards to possible cheating. So that kind of infuriated me more since we had just had a baby. Like I said, I had just got on medication about a week and a half before. I wanted to hurt him like I was hurting, and I knew that was one way that
Did you encourage or tell Julian at any point to give a false statement to police?
No.
Do you have any reason to believe that what Julian told the police was true?
no. Or, yes, sir. Can you repeat that again?
I can. I said, do you yourself have any reason to believe that Julian would give a false statement to police?
I do know that he had stated a few things in that police report that was not accurate after we had spoke. Afterwards, it was indicated that what he had said was not exactly what had happened. He had worded it incorrectly.
Can you tell me more about that?
Once I read the police report, it said something about being choked in there. That after speaking with Julian, after the matter with adrenaline and everything had calmed down, it was just, he had Brian's balls in his hand. And it was just, I guess, the commotion of everything. There was some pressure that he insinuated and felt like that was like not, there was no choking involved or punching.
That you witnessed, correct?
And that Julian had stated to me after the fact.
Has Julian been interviewed about what happened since the police spoke with him at your house that night?
Yeah.
Do you recall when that was?
It was shortly after the incident.
Do you know where that interview occurred?
My kitchen.
Were you present for that interview?
I was in the living room, but I could hear.
Did you talk to Julian about that interview prior to it happening? Did you talk to him afterwards? Did Ezra get interviewed by CPS?
All the children.
Okay. Were you present for all of their interviews?
Same thing. They were in the kitchen. I was in the living room. They told me that I was not able to be present.
But you could hear what the children were saying?
Sort of, yeah.
Okay. Ms. Dwight, is your husband here today?
Yes,
And can you please point to him and tell me what color his shirt is?
Light blue.
Identification for the record, Your Honor.
Any objection is identification.
None.
Identification is noted.
And your home on Devonshire Street, is that in the city of Lansing, County of Ingham? Nothing further, Your Honor. Thank you.
Cross-examination.
Mr. Dwight, my name is David Carter. I represent Brian in this matter. I'm going to only ask you a few questions, and it has to do with some questions that the prosecutor asked you. She asked you if there was, I believe, and maybe I'm summarizing, I won't get it exactly right, but any reason why Julian would be untruthful. Do you remember that kind of line of questioning? Is that do you remember that line? Yeah. Now, Julian really wanted to go live with his dad in Texas at that time.
Yes.
And his behavior in the house was getting out of control, wasn't it? Does Julian have a history of being deceptive?
Yes.
Thank you. I have nothing.
No, Your Honor, but I did want to address something that's not directly related to testimony of the case with the witness before she's dismissed. Thank you. Ms. Joy, did you receive a subpoena to come to court today?
Yes.
Did you also receive a subpoena for Julian to come to court today? And did you bring Julian to court today?
I did not.
Do you understand that it was a court order to bring Julian to court today?
Yes.
Can you tell me why he's not here?
As his mother and him being a minor, and he is going through a lot, and I do not want to backtrack his therapy that he is in, so I chose not to bring him.
Would you be willing to have Julian sit for a recorded forensic interview rather than bringing him to court?
No.
And can you tell me why that is?
I do not want to bring the situation back up to him. He is doing progress. I do not want to bring it back.
Would you comply with a court order requiring that you bring Julian in for an interview?
I do not want to bring him back into this situation as he is making progress in therapy.
So you would not comply with a court order for that? Thank you, Your Honor.
Okay, I have a follow-up question on that. Did the therapist tell you that you were not to bring him to court because it would backtrack his therapy?
No, ma'am.
Okay, you made this independent decision?
Yes, ma'am.
Okay, and are you a licensed therapist?
No, ma'am.
Have you gone to school and
No.
studied therapy?
No.
Okay, do you understand that a violation of a court order is contempt?
Yes, ma'am.
Do you know what the maximum penalty is for that?
No, ma'am.
93 days in jail and or $7,500 in fines. You understand that?
Yes, ma'am.
Okay. Any other questions?
No, Your Honor.
Okay, you can be excused. You can call your next witness.
Thank you, Your Honor. The people are actually going to be asking for a continuance of this matter. Given the testimony of this witness, there are going to be some additional people that need to be called. And so I'm going to be asking to continue this matter on a different date.
Okay, I'm going to grant the continuance and I want another subpoena for the minor.
Yes, Your Honor. Just so that the court is aware, I will be subpoenaing Chelsea Joy for that hearing as well.
Thank you. August 24th at 1:30.
I don't know if that works.
You have trial, I'm sure.
Pardon?
It's trial.
No, I think I'm
Always has
actually
trial.
on.
It does always have trial.
I think
Vacation?
I'm on vacation.
Mr. Carter, you're not allowed.
Well, then you can be here.
I'm taking my kid to college in
Oh,
Wisconsin.
that's
not
a pretty good
vacation.
excuse.
It is. It's the beginning of a long vacation.
Okay, sounds good.
And
You need
the
to go.
following week, I start a homicide trial in front of Judge Dragon Chuck.
Okay,
And that, I believe, is a 2-week trial.
September 14th works
Yes.
at 1:30. September 14th at 1:30.
Thank you, Your Honor.
No problem.
I'm sorry, 1:30?
Yes. 1:30.
I heard that and it seemed like.
It's different, but sounds like she's squeezing us in. Any additional matters for the record today?
Just to remind witnesses of sequestration that they're not to talk to about their testimony to any other potential witnesses in the case.
Okay, I don't recall there being a sequestration order, but I will grant one.
Thank you,
There
Your
is a
Honor.
sequestration order, so you're not to speak with any other witness or parties about your testimony, okay, ma'am? Okay, thank you.
Thank you, Your Honor. Appreciate that.
You're welcome.
Your Honor.
Thank you. Who's ready to go?
Have a good weekend, everyone.
Thank you.
Thank you. I'll send that stuff over there.
I need some strong coffee right now.
You know what?
Mr. Clover is here. Or Flower, Mr. Flower's here. Thought I saw his attorney is Mr. Flower's attorney here?
Yes, Your Honor, I'm here.
Okay, I'm trying to get back to Zoom. Okay, there we go. Okay, we're ready on Mr. Flower. Ready, Mr. Flower, okay. On the record in the matter, the people of the state of Michigan versus Cody Ray Calpower, file number 23-01846. Appearance, please.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
And good morning, Your Honor. May it please the court, Nathan Collison on behalf of Mr. Clower, who is present today via Zoom.
Okay, today was the date and the time that was set for preliminary examination. However, I stated I will treat it as a probable cause conference. Let's see. I think he had some matters pending in East Lansing. How are we proceeding today?
Your Honor, we would ask that this, actually, I do have officers here today. They didn't notice not to show up, so I would just ask that this be set for preliminary examination. I believe myself and the attorney are going to discuss this case.
Mr. Collison?
No objection, Your Honor.
Okay, we'll set this for preliminary examination. August 24th at 10:30. August 24th at 10:30.
Thank you, Your Honor.
No problem. Any additional matters for
Thank you.
today's record?
Not from the people, Your Honor.
Nothing on behalf of Mr. Clower. Thank you, Your Honor.
Thank you. You're all set.
Go release my officer.
Thank you. What do we got? I need to prosecute. On the record in the matter, she doesn't have an attorney either, right? The people of the state of Michigan versus Shaniqua Parker, file number 23-02121, council appearance.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
Okay, today was the date and time set for preliminary examination. The matter was scheduled for 9:30. It's currently 10:33, and that we've not seen Ms. Parker nor anyone that represents Ms. Parker. She did indicate to the court that she was retaining Toby White, but we've not gotten an appearance from him. A bench warrant will be issued and bond forfeiture. No problem. Thank you. Back on the record in the matter of the people of the state of Michigan versus Shaniqua Parker, council appearance.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
Okay, and Ms. Parker, you just knocked on my door and said you were at the wrong court. Did you go over to circuit court today?
Yes, I did.
Okay, did you forget that you came here before?
I never came here. I mean, I was on a Zoom.
Oh, you were on Zoom.
But,
You said you were gonna retain counsel Toby White. What happened with that?
Yes, I haven't been able to get a hold. Now, I've talked to him, but I haven't been able to come up with full funds. So I do get paid tomorrow, well, Friday, and I'm gonna take them all.
Okay, so you need more time to retain counsel?
Yes, yes.
Okay, so you have the right to have a preliminary examination within 21 days of your arraignment. You were arraigned back on July 10th. And so in order for me to adjourn it, I would need you to waive that timeline so I can give you a new date. Are you willing to waive the timeline to get a new date?
Yes.
Okay, no one's forcing you or threatening you to do that?
No.
Okay, let me get you a new date.
We can do August 10th at 10:30.
August 10th at 10:30. We'll get you a new notice to appear. August 10th at 10:30 is gonna be a PCC because I need to see an appearance first before I make him bring his officer back, okay? To the probable cause conference, okay? Okay, to the, a preliminary examination date will be set after that date, okay?
Okay.
You have any questions?
No, Your Honor, just for the record, we do have officers here and there is going to be a misdemeanor off from.
Okay. Okay, very good. So you'll be all set. We'll get you a copy of your notice and you'll come back to this courtroom on your next court date of August 10th, okay?
Thank you so much.
You're welcome.
I'm just going to go release my.
No problem. No problem.
Parker.
I didn't see yet. I'm confused.
Holbrook here?
Your Honor, I've had contact with Mr. Holbrook. His ride fell through. He's on his bike. He should be here. He said in the most.
Sounds good. And Larkin, didn't we see Larkin earlier this week? She here?
Yeah, she's talking about.
Oh, okay, sounds good. What about Watkins? I don't see Mr. Goodrich in here anymore. Did you see Watkins out there? Okay, let me do Williams. Williams here? On the record in the matter of the people of the state of Michigan versus Stephen Williams, file numbers 23-00434 and 23-02019. Council appearances.
Thank you, Your Honor. Dale Coltrader on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Williams. He's standing to my right.
Okay, Mr. Williams, you have two files here. One is a police officer fleeing third and assault with intention of great bodily harm, less than murder, and DD second. And my understanding is there's a request to adjourn because he's retained counsel.
That's correct, Your Honor. We're requesting an adjournment. I'll be waiving the timeline. We did speak with the attorney Koondreit. Pardon me, a person from Grand Rapids. Courtroom. And my computer doesn't work right now for some reason, so I can't actually.
Okay.
Anyway.
Looks like both the timelines in both were waived because he was never brought over from Acosta County originally, so I had to find good cause to go beyond the 21 days. So we don't need to address that, but we can just reset it so that you can get a substitution.
Right, I transmitted a substitution to their office yesterday. I haven't received anything back so far.
Okay, sounds good.
You want a PCC or exam?
I'm gonna say an exam because it was attorney could have appeared today if he obtained them, but he didn't. She did.
She is in court in Lake County.
Lake County?
So she's
Okay,
from-
give me a PCC and a PD.
Can do a PCC August 18th at 1. And then exam August 24th at 10:30.
Okay, your new probable cause conference will be August 18th at 1, and your exam will be August 24th at what time?
10:30.
At 10:30. And obviously, if those dates don't work or conflict with your new counsel's schedule, they can notify the court and we can adjust that, okay?
Yes, Your Honor.
Do you have any questions today?
No, Your Honor.
Okay, any additional matters for the record, counsel?
Not from the people, Your Honor.
Not from the defense, thank you.
We'll get you a copy of your notice to appear.
Thank you, Your Honor.
You're welcome.
It's gonna be a plus 4, 21 days in Robinson.
On the record in the matter of the people of the state of Michigan versus Michael Robinson, file number 23-02148, counsel appearance.
Thank you, Your Honor. Dale Culture. Yeah.
Mr. Robinson is present in the courtroom without counsel today, correct?
Yes.
At our last court date, you said you intended to hire an attorney?
Yes.
And how is that looking?
I hired her. She had a pre-paid vacation that she went on actually today. And she asked me if I could, or she told me to ask you if I can waive my 21.
What's your attorney's name?
Melissa Patrick.
Oh, okay. You mean, so she gets off, she finishes the trial and she goes on vacation? Is that what you mean?
Yeah, I guess so.
Okay. I will note that you retained counsel. Let's see here. You were arraigned on 12. Okay, so you have the right to have your exam within 21 days of your arraignment, and due to your hiring counsel who's on vacation, are you willing to waive the 21 days so that she can return and appear on this case?
Yes.
Okay. Nobody's making any promises or threats to you to get you to waive the timeline? We'll get you a new date for an exam.
You know, we have Malcolm Robinson here. Who's kind of kids that like to run together. Representing him.
Gotcha. August 24th at 1:30. August 24th at 1:30 will be your new exam date, okay? Do you have any questions today? Okay, you're all set. Thank you. No problem. On the record, is Mr. Abbott here? Yes. On the matters of the people of the state of Michigan versus Malcolm Robinson, file numbers 23-02147 and 22-03211 FY. Appearance, please.
Thank you, Your Honor. Dale Culture. On behalf of the
Counsel, appearance.
Good morning, Your Honor. John Abbott, representing
Malcolm Robinson.
Mr. Robinson.
I know you were eager to probably start your exam today, but this is a co-defendant. And the other one's not ready. So what do you want to do?
ready to go.
Officers are here, so you can do it. That's on both matters?
I've got to check to see if they're here on both matters. I know I have a couple officer problems. So.
Okay, sounds good. If I'll let you go figure out who you have, and then we'll figure out how we're moving forward.
She didn't understand what you were over. Stop. Don't mean to disturb. Thank you, sir.
Komarami is in custody?
It is, Judge.
Okay, where are we running that?
I understand the people intend to run the examination. I think I created a record last week about how it is the defense moved away.
Oh, got it.
Sounds to me like you have another exam to go. It's going to take a couple of minutes. If Your Honor doesn't mind, I'll go prepare, enjoying the fresh air of Inman County.
Sounds good.
Thank you.
I'm so.
147 FY.
Okay, they've decided that they would like this to run to wait for 21 days. They changed their mind. Okay, so that's the one that you were ready to proceed on today?
Yes.
Okay, so we're back on the record. Which matter? Malcolm Robinson 23-02147. Okay, and so this is the matter in which there is a co-defendant, and the co-defendant is seeking to hire counsel, co-defendant being your brother, I believe. And he's waived 21 days, and you'd like to waive your 21 days so that this exam can be run together, is that correct?
Yes.
Okay, anybody threatening you or making any promises to you to get you to waive the timeline?
No.
Okay, so we'll reset your matter as well. It's gonna be August 24th at 1:30. No problem. Okay, and then let's see. What's going on with the other matter? Are we resetting that one too? Are we resetting 22-03211? That's not a co-defendant matter, correct?
It's not.
Okay, how are we proceeding on that one?
Mayor, at this time, people do not have the ability to proceed with the lack of witness. However, I will indicate to the court that I have had contact with the witness. Yesterday, she indicated, she's actually a victim. She indicated she was called out of town to work. She will not be back in town until Friday. Based on that, I would ask for a very short adjournment. Serious matter involving a gun and some other issues. So
That's right.
We're prepared to proceed now. He's got the right to have the hearing within the time limit.
Okay, so you do have the right to have a preliminary examination within 21 days of your arraignment unless you waive the 21 days or the court finds good cause. In this case, the prosecution does not have a witness, but they have had contact with the alleged victim. The alleged victim has indicated their willingness to participate, but they're unavailable due to work requirement, and that in the court's determination is good cause. So I'll go beyond the timeline and reset that matter. We're gonna do that the same day, if we can? Yeah. August 24th at 1:30. Okay, any additional matters for today on this file?
not from the people, Your Honor.
Not from the defense.
Okay, you get your notice to appear on that one and you're all set.
Thank you.
No problem. Okay, let's see. Mr. Cornish has Ms. Larkin here.
She is, Your Honor. I was just discussing that with the prosecutor.
Sounds good.
I've got a vacation scheduled last week.
Vacation, what is this all about? Everyone's
talking
going on
about
vacation.
Not being here on
Mr.
the
Patrick's
24th.
on vacation, Mr. Carter wants to go on vacation, you wanna go on vacation, who, I mean,
I got 4
people
years.
need to be defended while you guys are taking days off.
I know.
So those days don't work for you.
24th don't work for me.
Fine. Can you give me a date?
September 14th.
Does September 14th work for you, or will you still be on vacation?
I will not be on vacation on the 14th.
Okay, well, we'll set up both Robinson matters and the other Robinson matter to September 14th. Thank you.
And I'd like to release my officer on that.
Thank you. People, can you write a note and then we change the dates?
Thanks.
Okay, well, Phelan is in custody of the Sarts here today.
I'm covered, Mr. Sargent.
Are we running that?
I believe there was an.
Oh, that's right. I started that one already. That's exactly what happened. Okay, and then
I think we're ready to go on the record for Larkin.
for Larkin, Okay, we're on the record in the matter. Where matters of the people of the state of Michigan versus Ayanna Larkin, file numbers 23-00082 and 23-01608. Council appearance.
Governor Dale Coltrader on behalf of the people.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornell on behalf of Ms. Larkin, who's in the court and standing to my right.
How are you, Ms. Larkin?
Your Honor, at this time, I have some witnesses on one case. Unfortunately, I do not have a victim present on that case, so
Which
I
one?
do not believe I can
Oh.
proceed.
On the
That
file
would
ended
be
in
the
28?
T case 23-00082T.
Okay. Mr. Cornish.
Thank you, Your Honor. We move for dismissal, understanding that we without prejudice. For the record, that means that they could reissue these if people showed up in the future and demanded.
Motion to dismiss without prejudice is granted. And the other file.
Your Honor, I do not have a victim witness here. I will indicate to the court, though I did speak with her last week. Very adamant that she was going to be here, so I'm not sure why she's not here.
Okay. Council.
Thank you, Your Honor. Once again, move for the matter to be dismissed. Unlike previous cases before the court, I don't think there was some sort of work excuse or good cause. Certainly, they have the right to reissue these, just like the other one, if she were to come forward and requested or demanded of the prosecution. Thank you.
Motion to dismiss without prejudice is granted. We'll get you a copy of the nollies for both, okay?
Thank you, Your Honor.
You're welcome. Holbrook is on his bicycle. We might be there though, because Ms. Donnelly stepped out. Williams, didn't we do Williams? We did. Did I make that up? Yeah, he hired an attorney. He
Mr.
did.
Watkins.
Watkins, I just did a bench warrant.
Showed up.
I just signed a bench warrant for Watkins
I'm gonna
because
let my officer go.
his attorney said that he had no contact. Finish Stalin and Holbrook. And then we just got Komarami. stated on the record in the matters of people of the state of Michigan versus Casey Stalin or Stalin, file numbers 23-02088 and 23-01844. Appearance, please.
Thank you, Your Honor. Bill Coltrane on behalf of the people.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. Stalin, who's in the court with Steve tonight, right? You say good morning to the court, please.
Good morning.
Okay, good morning. I adjourned this matter just so that we could get a certified copy of this prior conviction. I think I gave the remaining portion of my ruling on the record last week as it related to probable cause. Were we able to get a certified copy?
Your Honor, we did not get one. However, I do have some case law on point that I would present to the court.
Okay.
That would be People versus Ryan Bach, that's 459 Mich 109. It seems to indicate in that there is no requirement the prosecutor prove the existence of prior convictions or more accurately demonstrate probable cause to believe convictions exist at a preliminary examination. Rather, MCL 257 625, which is the drunk driving statute, does provide simply that a prosecutor must only include in the complaint information and information statement listing defendant's prior convictions, indicate a preliminary exam is not the appropriate stage to challenge the validity of prior convictions to be used for sentencing enhancements. Here, this is a sentencing enhancement, no different than a HAB or a drunk driving case. Purpose, and that's the purpose. We just have to provide notice. The proper place to challenge that would be after conviction at sentencing. So I would ask you, based on your prior ruling, that there was probable cause in both cases to find this case.
Thank you, Your Honor. As the court is aware, Mr. Sartz's cases, I was here covering for him today. My understanding, based on the case law that was presented to me this morning from Mr. Faultrider, it doesn't sound like they need it. I would defer to the court on that decision. If it turns out that is inaccurate case law, I know that Mr. Sartz would be more than happy to file a motion to quash.
Thank you.
And also, Your Honor, if I could, I would indicate when Mr. Sartz is making his closing statements, I think one statement you made was that people had reached the bare minimum of getting it found over by not presenting certified copy.
That is what he stated at the time of his argument. I have looked up case law myself, and I found case law consistent with what the prosecutor stated as it relates to the requirement for the preliminary examination. And in one file, Mr. Stalin is charged with domestic violence, third offense notice, and then there's a habitual offender, fourth offense notice, enhancing the sentence. And in the other file, there's a similar enhancement. It's a domestic violence third, and I think there is, again, a third offense notice on that and a habitual fourth. And so I will rely on the case law stated on the record, and I will find that the people have met their burden as it relates to probable cause in both matters. And so those matters will be both bound over to the circuit court. Again, I gave my full findings at the last court date. And the date's going to be August 9th. You do not need to appear in court on August 9th. That's the day that they'll get the files from the district court, okay?
All right, thank you.
Your next court date will be in circuit court. They will be pre-trials, and then Mr. Sartz will be made aware of that date, okay? Do you have any questions?
Oh, man.
Thank you, Your Honor.
No
Thank you, Your
problem.
Honor.
Thank you. You're all set.
I think people are ready to proceed on.
As we know,
We do have a matter, Mr. Holbrook.
Did Mr. Holbrook make it?
Your Honor, I have not seen him yet. I was continuing to wait for him in case he did show.
I do have an officer.
Okay, where's he riding a bicycle from?
He said his ride fell through.
Yeah, but I was wondering, where is he biking from? Is it Lansing?
He lives on Bourne Trail. I think it's south of here. It's almost near Port.
You can release your officer. I'll issue a bench warrant. If he does appear today, I'll just reset it.
Okay.
Yeah.
Have a good day. You too. See you at the shop, boss.
All right, thank you.
Officer. Was your phone? Yes, sir. Okay. Just making sure that somebody's here.
Mr. Holbrook.
Okay.
Sorry about that. I'm gonna go talk to you.
Is it okay for him to sit here? Okay, I guess I'll need to slide over. Or can I put his chair here? So I can table space. So, yeah, if you don't mind. Just that table space. Oh. Like right here, she's in the crowd, man, I got a copy.
I assume you're gonna sit back there then.
Yes, she will. I think I take into consideration the convenience of other people. Well, I don't know. Thank you for taking out stuff.
Try not to assume too much things.
Stand up.
Yeah.
All rise.
Seated. Okay, on the record in the matter of the people of the state of Michigan versus Gavin Komarami. File number is 23-01855. Council appearance.
Your Honor, Dale Coulter on behalf of the people.
Your Honor, good morning. My name is Keith Watson. I'm a public defender. I'm here today on behalf of Gavin Komarami, who is present to my right.
Okay, Mr. Komarami, today's the date that's set for your preliminary examination. Council, are we proceeding at this time?
We'll be proceeding with the examination. Your Honor, we're prepared to proceed.
Okay, any preliminary matters?
Your Honor.
Sequestration of witnesses.
Okay, sequestration is granted. How many witnesses do you have? How many witnesses do you
I
have?
will have 2 witnesses.
And no one's in the courtroom now?
Just the lead detective. I think under.
Just the lead detective and one other witness, or 2 other witnesses?
Then I have the victim.
Okay, sounds good. You can call your witness.
Thank you. I'm going to call. Stand your honor like that.
Sir.
This time, your honor, people will call Mason.
Raise your right hand.
Mason Brown.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat. Okay, and there's a microphone that's in front of you, and the lady behind you is my court recorder. She has to take down everything being stated here, so your responses must be verbal. You can't do head nods and shakes or mm-hms and uh-hs because we can't write that into the record accurately.
Okay.
Okay, and then you have a nice loud voice, so that's good. Keep your voice up. And then if there's an eviction, there's an objection by either of the parties, you would stop your statements. I will give you a ruling as to whether or not you can give that response or not, okay?
Okay.
I'll state your first and last name and spell both of them.
Mason Brown, MASON BROWN.
Thank you. You can proceed.
Thank you, your honor. Now, Mr. Brown, you reside in the city of Lansing?
Yep.
And I've said yes.
Okay.
And I know this is, you've never testified before, so just speak up and speak slowly and clearly. Great. I'm going to take your attention back to last year on August 16th, 2022. Were you in the city of Lansing on that day?
Yes.
And you were attempting to sell a pair of shoes, is that correct?
Yes.
Can you tell us a little bit about where were you trying to sell those shoes?
I was trying to sell them on Facebook Marketplace locally.
What kind of shoes were those?
They were Yeezy 700s.
Okay. And at some point, did anyone, I'm assuming you put an ad out?
Yep, I had it up for a while.
Okay. Assuming at some point someone
We have to
responded to
object to
that.
continue this meeting. It's not as if there's anything that's been demonstrated by this witness that he must be led.
There's objection to leading.
I can.
Okay, thank you. Objection sustained.
What was your intent on that day?
To sell those shoes.
Okay. And how were you attempting to do that?
I was gonna trade them for cash, $220. And so I had a message on Facebook the day before.
At any point, did you have an offer?
Yep, for $220. Or I believe it was 240 actually. He said he sent me a video of the money and said he was gonna meet me.
Okay. Where were you supposed to meet him?
I was gonna meet at the corner, at the QD on the corner of MLK and Mount Hope.
Okay. And why at that location?
Because it's 3 blocks from my house, so that makes it the closest public meetup area where there's people most of the time.
Want to meet in public?
Yep.
Why is that?
So stuff like this doesn't happen. Stuff like me getting shot doesn't happen. So I'm not worrying about someone bringing a knife or, in this case, a gun.
Do you recall, was there a name attached to the person who was going to contact you that day or meet you?
Yeah, it was
Question calls for hearsay.
You said, did you recall
Being
what?
offered for whether it's true or not, it's being offered for why, what's that location?
What was the question again?
I asked if there was a name attached to the Facebook account.
Okay, objections overruled.
Thank you.
Gavin Komarami was the name on the Facebook account.
And what time did you go to that location?
It was, I believe it was right around 3 p.m.
Okay. And did you meet anyone there that day?
Yep, after waiting for about 10 minutes, Gavin Komarami messaged me and said he was pulling up, and then he and someone else walked up.
You said he messaged you on?
Yep, on Facebook. Yep.
Did that person arrive?
Yep, he did, and with someone else.
Okay. Did you recognize him at the time he arrived?
No, I didn't recognize either. I mean, I recognized what he looked like, but I never saw them before in the past, either of them.
So after they arrived, what happened?
I pulled out one of the shoes, showed it to them like I do with all my clients, to show them the shoe so they know what they're getting. Then I turned around to grab my phone so I could show them the receipt for the shoes. And I turned back around and he was holding a gun no more than a foot away from me, probably 8 to 10 inches away from me. He said, "What are we gonna do?"
You have to object to the
Where
narrative.
were you?
There's an objection as to narrative. Thank you. Objections.
So where were you standing at that time?
When what?
When
At
you
what time?
got the shoes, yes.
When I was standing about a foot outside of my car, and he and the other guy were both right there.
Where were the shoes at?
The shoes were in my hand.
Okay. And after you retrieved the shoes, then what happened? You turned around.
I turned around.
Object to the leading.
Okay. He did already state on the record that he had turned around, so he's just redirecting them back to that.
Thank you.
I turned around to grab my phone and show him the receipt off the shoes because it's just something I do while selling shoes.
Okay.
Yeah.
Was there any conversation between the two of you at that time?
It was really just me talking. They were really nonverbal.
Okay.
Just giving, like, shaking their head yes and no. I was telling them, making sure the shoes are real and everything, because that's obviously a problem too. So I want to make some of my clients again.
So what happened after the gun was pointed at you?
Yeah, he pointed at me and said, "What are we gonna do?" And
Who said that?
Gavin said that.
And then what happened after that?
I went and tried to knock it out of his hands, and then I was shot instantly after that, and then I did knock it out of his hands. And
how close was he to you at this time?
Before I was shot or after I was shot? Before I was shot, the gun was about no more than a foot away from me. I thought it was at 8 to 10 inches.
You describe where the gun was pointing.
Yeah, it was pointing right around like my lower left stomach thigh area, pointing up, obviously. So that's when I had.
Okay. Now, do you see that person in the courtroom today?
Yep.
And where are they seated? Can you
3 over from me.
Can you describe something that person's wearing?
Orange slides and a navy shirt.
Okay. And let the record reflect is identified.
Any objection?
Not at this point, Your Honor, the subject to cross-examination.
Okay, sounds good.
Now, what location were you at when this happened?
The Quality Dairy on Mount Hope and MLK.
And located in the city of Lansing?
Yes, it is.
Hingham County?
Yes, it is.
Michigan?
Yes.
Okay, now subsequently you say you were shot?
Yes.
Where were you shot?
On the left side of my stomach, like over.
Let the record reflect pointing to his left
On the left side of my stomach, like more kind of towards the side.
What happened after you were shot?
After I was shot, I went into the hospital and they removed part of my large and my small intestine. Well, the bullet was split into 12 different pieces.
Let's back up.
Okay.
I mean,
Yeah.
immediately after.
Immediately after I was shot, okay, yeah. I knocked the gun out of his hands and the gun was on the ground. I went and put both of my hands on the gun with all my weight while him and his friend were trying to get me off the gun so they could retrieve the gun. And after about 45 seconds to a minute when they couldn't get the gun, they.
At some point, did they get the gun away from you?
They didn't get the gun away from me until I got off the gun and went into QD to tell them I was just shot.
Okay. Now, after you were shot, did emergency medical respond?
Yep, I'd say after about 4 or 5 minutes.
Okay, and you were still conscious at this
Yep.
point? Do you recall the police responding that day?
Yep, they were there like a minute. Ambulance.
Okay. Did you have any discussions with the officers that day?
No, they just asked me if some other people walking by were the shooters, and I said no. That was the only thing I remember from that conversation.
Said what?
There were some other people that were walking by that wasn't him. It was a dark-skinned guy, and they asked me if that was the guy that just shot me, and I said no. That's the only conversation I remember.
Okay. And were you transported to the hospital then?
Yep, I was transported right to the hospital.
You know what hospital you went to?
Sparrow Hospital.
How long were you in the hospital?
At that time, I was there for about a week.
The length of the stay in the hospital, Your Honor, is irrelevant to this examination. So it's all objective.
Did you want to respond to the objection?
Just laying a foundation for the injuries he said.
We can move on.
Injury is not a component of these offenses.
The objection is sustained. You can move on.
Thank you.
Now, let's be clear, you do recognize person in the courtroom today.
Yes, I do.
Asked and answered.
Did anything else unusual happen that day?
No, besides getting shot by a bullet that split into 12 pieces and been dealing with every
I
day
object to the
since.
hearsay, Your Honor, what the witness has stated concerning the bullet being split into 12 pieces. He has no personal knowledge of this.
Just want to respond?
Not at this point.
Thank you. Objection sustained.
Thank you.
Are you continuing your questioning?
I have no further questions.
Cross examination.
Mr. Brown, good morning. Still morning. So you tell us that you exchanged Facebook messages with a person that had the profile of the name Gavin Komarami. Is that correct?
Yes.
Have you had any other prior exchanges on Facebook Marketplace with this person or Facebook Messenger?
I don't believe so.
With that profile?
I don't believe so.
One of the things you said on direct examination is that you talk about your clients. Does this mean that you're in the business of selling things like shoes on Facebook Marketplace?
I was in the business of selling shoes
Up
while I was
until
shot.
At this point, okay.
Yeah.
And you would regularly use the Quality Dairy store because, as you told us, you figured that was a safer place than having somebody come to your home, isn't that right?
Yes.
And this was near your home. You said 3 blocks away, isn't that
Yes.
right? Okay. But because it was public, you felt that that was the best place for you to do such a thing, right?
Yes.
Okay. You say that your assailants, and there were a pair of them, correct?
Sorry, can you repeat that?
You say that there was a pair of your assailants, isn't that right?
A pair of my what?
Assailants, 2 people.
Yes.
Okay, 2 people were involved in this sale, apparently of a shoe, correct?
Yes.
Right. And you said that those 2 people, they arrived on foot, is that right?
Yeah, on the Facebook Messenger.
Well, that's not what I asked you. I didn't ask about Facebook Messenger. What I asked you is you observed them arriving on foot.
Yes, I did.
That's what I
observe
needed to
them
know. Thank
arriving
you
on
very
foot.
much. And when they arrived, you handed one of those people a shoe, is that correct?
Yes.
Okay. And the person that you handed the shoe, is that the person that you identified today, or is that the other person?
That is the person I identified today.
Okay. So when that happened, this happened outside of what, your vehicle?
Yes.
Okay. in the doorway of your vehicle?
What do you mean?
Well,
Was
well, tell me this, was your car, was it a car or a truck?
It was a car.
Okay, was your car door open?
I can't recall.
Okay,
honestly.
where were you standing then when you handed a shoe, as you tell us to my client?
I was standing about 2 feet, 3 feet in front of my car.
Okay, 2-3 feet in front of your car. That
Not
is
in front of my car, in front of the door of my
in front
car.
of the door of your car.
Yes.
That is the driver's side door?
Yeah, the
Was the driver's side door open?
Like I said, I can't recall. It might have been
Okay,
open,
that's
it might have not.
Might have been open, might not have been. Thank you. And you tell us, well, you told law enforcement at one point that the reason why it is you showed one shoe and not a pair of shoes is because you've been ripped off before. Is that right?
Yes.
Okay, you've been ripped off because you pass off a pair of shoes. Next thing you know, somebody split with both the shoes and you don't have your money.
Yes.
Right? So you used one shoe as sort of a sample, right?
Yeah.
To be inspected, correct?
Yeah.
Okay, was this shoe passed from one person to the next? That is between those two people who had approached you?
I don't understand what you're asking.
You
You're
passed
asking
the
if-
shoe, let me get it straight here. You passed the shoe to the person you identify as my client, correct?
Yes.
Okay, then, did that shoe then get passed to somebody else?
No, it didn't.
Okay, so it stayed then in the possession of the person that you identify as my client?
Yeah.
Okay, and that shoe, did that then leave with my client ultimately?
Well, I pulled out the shoe to show it to him. I was showing it to him. I don't even know if he grabbed it. I was
Okay,
showing
that's what
him
I was
the
getting
shoe.
at. That's what I was getting
I was
at,
showing-
about whether it was passed off.
Yeah.
So you didn't actually hand it to the person you identify as my client, correct?
I don't recall.
You don't recall? Okay. I thought you said directly before
I
this,
pulled
when we
out
were
one of the
discussing,
shoes, yeah.
let me ask the questions. I thought that you had said that you had handed the shoe to a person.
And I'm gonna object, being argumentative, he's not really asking.
You're not arguing
He's
arguing
trying
at
to
all, Your Honor.
answer the question, not ignore it.
Arguing,
Okay,
Your
well,
Honor,
I
has
think
to
he
do
said he
with
don't
the means of the
recall. So maybe you can object to ask and answer, but I think he's trying to clarify. Do
That's all I'm
you,
trying
do you know the answer or not, sir? To his question?
He's asked like
I can
5
ask-
questions.
I can ask
last-
the question more clearly, Your Honor.
Okay, restate
But
the
as far as
question.
argument is concerned, argument has to do with discussing the meaning of a fact, and I have not done so.
Okay, objection overruled.
Thank you. But I just want to be very clear, so I'm going to slow it down, a little bit, okay, so that you can give me the answers, and we'll go one step at a time, okay? All right? Yes?
Yes.
Fine. Did you hand a shoe to another person in that Quality Dairy parking lot that day?
No.
Fine. You showed a shoe to a person in that Quality Dairy parking lot that day, correct?
Correct.
The person that you tell us you showed the shoe to is the person that you today identify as my client, correct? All right. On direct examination, when the prosecutor was asking you questions, you kept referring to my client as Gavin, correct?
Correct.
Okay, I want to make sure that we are clear. You spoke to law enforcement officers multiple times during the course of the investigation of this case. Is that correct?
Yes.
It's okay if you did. I'm not saying that it's wrong for you to talk to a cop, all right? I'm just trying to get the handle on this. You spoke to law enforcement, as you tell us on direct examination, the very day that you were shot, correct?
Yes.
Okay, at the Quality Dairy, correct?
Yes.
Also, you spoke to law enforcement again, certainly at the hospital, you remember that, right?
Yes.
Okay. And you spoke to law enforcement again at a different time, is that correct?
Yes.
When you spoke to law enforcement, was it always this person who sits next to the prosecuting attorney, or did it include somebody else as well? Or don't you recall? And if you don't recall, that's okay. I just want to be specific and clear.
I don't recall, but I think Detective Brady is the only person.
Okay.
In the hospital, Detective Brady was the only person. I'm
Fine,
almost sure.
I'll
but
get to that later.
afterwards, it might-
Thank you. I'll get to that later. Drawing your attention back to this scene at the Quality Dairy parking lot, where you say you are outside of your car showing a shoe. That's where it is. I want to focus your attention now, okay? Okay?
Okay.
Thank you. You then reached into your car, correct?
Correct.
You reached into your car to grab your phone, correct?
Correct.
And you reached into your car to grab your phone so that you could show a picture of something, correct?
Not correct.
Oh, you didn't reach into your phone to show the picture of a receipt to show your
No,
proof of
I was
ownership?
gonna show the email receipt. It wasn't a picture of a
Oh,
receipt.
okay,
It was
an email receipt, but that was on your phone, right?
Yes, on my
Okay,
phone.
and that's when it is you turn around, correct?
Yes.
And when you turn around, that's where it is you see a gun, correct?
Yes, correct.
Fine. When you were reaching for your phone, was your phone in your car?
Yes.
Okay, so are we to then assume that you opened the car door to get into the car to reach for your phone?
What are you asking?
Did you get inside of your car to reach for your phone?
No, I have long arms. I reached into my phone.
That's what I was getting at. So now you remember that that car door was closed when you reached in to get your phone. Is that right? Is that correct?
Can you rephrase it?
Sure. Your car door was closed when you reached in for your phone.
I just told you a minute ago, I don't know if, I don't recall if my car door was closed or open, and you're asking again.
Okay. Where was your phone in your car when you reached in with your long arms to find your phone?
In the center.
The center console?
Yes.
Okay. Front center console?
Yes.
Okay, between the driver's seat and the passenger
Yes,
seat in
between
the front.
driver's seat and the passenger
Fine.
seat.
So when you then turned around with your phone in hand, you had your phone in your hand when you turned around?
Yes.
Okay, when you did that, that's when it is you discovered a gun, correct?
Yes.
Okay. And you described this gun as a black handgun, correct?
Yes.
Okay. You are sure that it was not a revolver, correct?
Yes.
And you know the difference between a revolver and a semi-automatic handgun, correct?
Correct.
Okay. Was this an all-black handgun?
Yep.
You know the difference between a full-size handgun and a compact handgun? One being large, the other being small?
Yes.
Was this a large all-black handgun, or was this a small all-black handgun?
Large.
Was this a fat all-black large handgun, or a thin black all-black handgun?
A fat or thin?
Yes, that is why, the width of it.
I know what fat and thin is.
Well, you asked the question.
Well,
so I
in
wanted to
the
clarify.
cases, I've never heard a gun identified to as fat and thin. That's
All right.
But
You're familiar with
I would
guns?
say it's fat.
You're familiar with guns?
I'm familiar with guns, but I've never heard of
Okay, if you're
guns.
familiar with guns, then you understand if I were to ask you the difference between something that would be a single stack gun or a double stack gun, correct?
I wouldn't if you asked me, no.
You wouldn't understand.
A
That's
double
why I
stack
asked
and a
fat or
single
thin.
stack, no, I wouldn't understand that.
Was the gun wide or was the gun thin?
The gun, what I would say was medium size, but it was fat. Okay, we'll say fat.
I'm just trying to get.
We'll say fat, because I wouldn't know the difference between a fat and a skinny gun.
I'm sorry, man. You're the one who observed it, and that's why it is I'm trying to get as best a description of this gun as I can. Right?
Okay.
You said that you have some familiarity with guns, and that's fine, right? So that's why it is I started asking questions about double stack or single stack, right? You know, do you know that difference?
I don't know.
Oh, okay, fine, then I won't ask
Double or
that.
single stack.
Fine. So you say that, however, that you could see the bullets on the top. Is that right?
Yes.
Okay. Seeing the bullets on the top of the gun, you believe that this is a semi-automatic gun, correct? Not a revolver. Is that right?
Yes.
Okay. So you say that you can see the bullets on the gun, on the top of the gun?
Wait, I might have said I could see the bullets on the top of the gun, but I didn't say bullets. I meant bullet. I could see one bullet in like a little spot where on the old black handgun where it looked like it was open or jammed in this case, as we discovered later.
As we discovered later, did you personally discover something about the gun being jammed? Or is this something that is the subject of some later conversation that you had with law enforcement?
I would have thought it was jammed again, or I would have been
Fine.
shot more than once from the
You
second.
presume that you would have been shot more than once,
Yes,
but you don't know how many times you may have been shot. You probably presumed before you came to that quality dairy that you wouldn't be shot at all that day.
I did.
Fair
presume
enough?
that.
Is
Fair
that
enough.
right? Okay, let's move along. When you say that the person who that you identify as my client presented then with a gun, when you had turned around with the phone, okay, I want to draw your attention to that. How far away was the person that you identify as my client away from you?
No more than a foot.
The person himself was a foot, no more than a foot away
Asked and
from
answered,
you?
you said a foot, Your Honor.
Is that right?
Objection, ask and answer.
It's not asked and answered, Judge, and if I may respond. The reason why is I didn't ask about the gun. I asked now to clarify whether the person was within a foot. And this witness now says that the person, that is the body, the corpus, was no more than a foot away from him. And that was my clarifying question.
Okay, so you can,
We will
I thought you were
overrule
talking
the
about
objection,
the
Your
gun.
Honor.
okay, you can overrule the objection, correct.
Thank you. May I
Proceed.
approach the witness?
Okay,
So witness, you say that the person who was
well, he just
identified,
clarified, he said he thought you were talking about the gun. He just said that.
that's fine.
Your Honor, I'm trying to figure out why he's approaching the witness.
Yes.
It's not to intimidate him.
It's not to intimidate at all, Your Honor. It is demonstrative.
What are you trying to demonstrate?
Well, upon receiving the answer that the person was within a foot, no more than a
He
foot
just
from the
corrected that.
witness.
So then you don't need to demonstrate that for him.
That's fine. So let me ask a more clarifying question. I'll retreat and then I'll ask to approach the witness again in a
Thank you.
moment.
Thank you.
Witness, you tell us that the person was,
Still right next to the witness.
Can you give this witness some space?
if I stand next to the prosecuting attorney, would that be all right?
That's fine.
Thank you. Now, witness, you tell us now in a clarifying answer that it wasn't the person that was no more than a foot from you. Did you mean to tell us then that the gun was no more than a foot from you?
Yes.
Was the person holding the gun extending that person's arm that held the gun?
They were extending their arm, not fully, but they were extending it to some extent.
Won't you please stand for us and show us what the arm looked like? Pretend, just for a second, if you don't mind standing up so we get a clear picture. And then show us what the arm that held, or the hand that held the gun, how it was held by that person.
Really like this.
All right, I see that the witness has held his right hand out. The right upper arm is up against the witness's body. The arm is facing forward, not quite at a 90-degree bend of the elbow. The witness's hand is palm up. Thank you. Any objection?
My palm didn't have anything to do. I was just putting how his arm was like, his hand was obviously on the trigger, so his palm was nothing like this.
Thank you. But I didn't ask anything about a hand on a trigger, but I will move along there. Thank you.
Thank you. So
And
noted.
so when that happened, you tell us then that the gun, are we clear, that the gun itself was no more than a foot away from you. Is that fair to say?
Yes.
Okay. And the forearm of the hand that held the gun was pointing in your direction, correct?
Yes.
You told us where on your body it was pointed already on direct examination, so I don't need to get into that. But I noticed you held your right hand when you showed us, right? Yes?
Yes.
Okay. Are you then meaning to tell us, by showing us that with your body, that the person who held the gun and pointed the gun at you used his right hand to hold the gun and point it?
Yes.
Okay, and you're confident in that?
I'm 100%.
Okay.
Yes.
And when you saw that gun, you tried to take that gun away from that person. Isn't that fair to say?
Yes.
Okay. A struggle ensued. Is that fair to say?
Yes.
A physical altercation between you and the person who held the gun.
But yeah, the physical altercation happened after I was shot in my side.
Okay. So it's not as if you tried to get a hold of the gun and then you were shot. You tried to get a hold of the gun after you were shot. Fair?
Yes.
Thank you. And was this gun held by one hand or by two hands of the person who shot you?
One hand.
There came a time then on the 19th of August of 2022 that you were in the hospital, that is Sparrow Hospital, right?
Yes.
Okay. And you were presented a photo array by Trooper Bradley Johnson, or Jonathan Bradley, isn't that correct?
Yes.
I have a question. I want to draw your attention back to that scene with the gun. Remember how we were talking about who was holding a gun, where, and how?
Yes.
Okay, I want to draw your attention back to that for a second. Okay. You don't know from where the gun was pulled by the person who shot you. Is that right?
Yes.
You don't know, but if it came out of the pants or out of under a jacket or anything like that.
I
Right?
don't know.
Okay. Because it was when you turned around that you first saw the gun, right?
Yes.
Okay. And when you first saw that gun was what? Pointed at you?
Yes.
Okay. And one of the things you told us before, I told you I'd get back to, is you tell us that you thought that a finger was on the trigger at the time that you first observed the gun. Is that right?
Yes.
Okay. One of the two people that was involved in this, you would describe as a person with a male, correct?
Yes.
With curly hair, correct?
Yes.
Appeared to be either Mexican or light skinned, is that correct?
Yes.
Okay. What was it, as you recall, that the person that you identify as my client was wearing that day at that quality dairy?
He was wearing a black hoodie.
Any markings on that hoodie?
No.
Was the hood up or down?
Up.
Now you use your own name, don't you, on your Facebook, as your Facebook profile, is that right?
Yes.
Drawing your attention now to the time that you were at the hospital and Trooper Jonathan Brady appeared. Did he interview you?
Yes.
That is, asked you questions?
Yes.
And when he asked you questions, how long was it that he was in your presence that day?
I don't recall.
Were you in a hospital bed when that happened?
Yes.
In your room?
Yes.
Or were you in the emergency room? Do you remember?
In my room.
Okay. So you had already been admitted and you were in your own room, is that right?
Correct.
Is there anybody else present in that room besides you and the trooper?
My mom.
Your mother? Was your mother present during the entire time that the trooper was present?
I don't recall.
Present at the beginning of your contact that day at the hospital room with the trooper?
Yes.
Was the trooper dressed in regular civilian clothing as he appears today?
Yes.
Okay. Not in a uniform?
No.
This interview involved follow-up questions from some prior interview, is that correct? When you spoke to the trooper at the hospital room from your hospital bed that day that we were just talking about, was this some sort of a follow-up interview between you and the trooper?
I believe this was my first time meeting
This
him.
is the first time meeting. That's what I was getting at. Okay. You were presented certain folders with pictures in them. Is that fair to say?
Yes.
When you were presented those folders, was there a time when you were provided a form to fill out?
I don't recall.
When you were in the hospital that day, when the trooper came by and you were in your hospital bed, were you in pain?
Yes.
Sounds stupid for me to ask. You've been shot, I recognize that. But does that mean that that you received some pain medication? Or don't you recall?
I don't believe I was on pain medication any day after the day I was shot when they did the surgery. I might have, I know I was weeks later when I was dealing with infection.
Sure.
But not on that day.
I'm getting to that day. That's what I'm trying to find.
Okay. I don't believe
When you were in the
so.
hospital bed talking to the trooper.
Yeah.
When you were presented the folders with pictures that day.
Yeah.
You were not on any medication. You were given certain instructions. Were those instructions read to you?
Yeah.
Okay. These instructions may have sounded something like this. You tell me if this sounds familiar to you. I am going to show you a group of photographs. Does that sound familiar to me?
If I am going to show a group of photographs sound familiar?
Yeah. That may have been read to you?
I don't recall. It sounds kind of familiar, but
The fact that the photographs are shown to you should not influence your judgment? Was that read to you?
I don't recall.
You should neither conclude nor guess that the photographs contain a picture of the person who committed a crime. Was that read to you?
This is all starting to sound more familiar now that you're saying it all at once.
Was that read to you?
I believe so.
Fine. You do not have to identify anyone. Was that read to you?
If you read it all at once, I would have been able to just tell you it was read to me at the beginning, but yeah, I believe that was read to me.
So you recall that you were given certain instructions?
Yes.
Okay. And when you were given certain instructions, you were also provided a form to actually fill out, correct? Fill in the blanks?
I don't recall. No.
Okay. May I approach the witness, Your Honor?
You may.
Witness, I'm going to hand you something. You don't have to say anything about it at all. I'm going to hand it to you and draw your attention to it. Is this your handwriting, the word YEP, Y-E-P? Is that your handwriting?
No, that's not.
That's not your handwriting. Okay. Is this your signature where it says signature of witness?
Yep.
Thank you.
That is my signature. All right.
When you signed signature of witness, you recognized that you signed a statement, correct?
Yes.
Okay. And did you print your name then as well, where it says I, Mason Brown? You signed it and printed your name?
I believe so. I taught him then.
Yes.
Yes.
Okay, fine. When you presented that folder with those pictures, you were able to identify somebody, correct?
Right.
Okay. May I approach the witness again?
You may.
Same form. Witness, I'm gonna show you something that I've circled here. The blue pen here, that's my pen.
Yeah.
Everything else is black and white.
Yeah.
Okay. It reads here, comments made by witness during photographic lineup. Quote, I believe it's number 3 or #3. Did I read that correctly?
Yes.
So are we to assume then that you told the trooper that you thought number 3 was the person that was identified by you as the person who shot you?
Yes.
I don't have any other questions of the witness at this time. Thank you.
Redirect.
When you first arrived at Quality Dairy, how long was it before other 2 individuals showed up?
I was waiting for about 10 minutes.
They were on foot?
Yep, they were on foot. They're coming from the same way my house was.
When you first had contact with them, did you notice a firearm?
No, I did not.
First noticed the firearm after.
You have to object to the leading.
The objection is to leading.
When
It
did you
is.
first notice the firearm?
Okay, sustain.
When did you first notice the firearm?
When I turned around.
And how long had they been there?
How long have they been standing there?
Yes.
I'd say about 45 seconds to a minute and a half. No longer than, probably more on the 45-second side.
Sure, this is the person who shot you.
Yes.
How long ago did this happen?
August 16th, so about almost a year now.
No further questions.
May this witness be excused?
I have no further questions.
Any chance, Your Honor, I can ask some brief clarifying questions?
Based on his last questions?
Yes,
Okay, I'll allow it.
thank you. It's fair to say that your police interviews occurred much closer in time to the event that took place, that is the shooting, than today as you testified. Is that right?
I'm going to object, Your Honor. I don't know how this is clarifying what I asked him. I asked him how long before they showed up and did he notice, did he see a gun when they first walked out?
How long before the subject showed up?
Right at the location.
And you want to know about the proximity of his first statement versus now?
Mr. Caltrider's last question had to do with how long it's been since the event. I was clarifying concerning that, having to do with the witness's memory being more clear, close in time as compared to now, as a result of the question of Mr. Caltrider.
That's not right.
I believe he was asking questions about the interview, not about how long ago this happened.
He
I
asked,
was.
well, he was asking, was the interview then closer in time to the incident than now, correct?
Right.
That's what I
It has to do with
thought.
the witness's memory. and
The objection's
impediments to
overruled.
perception. Thank you. So is that fair to say?
Can you repeat the question?
Sure. Your law enforcement interviews were much closer in time to the event of your shooting than today when you tell us that you are sure that the person who shot you is my client.
Yes.
Okay. And all of this event took place within 45 seconds to a minute and a half, correct? I mean, that's what it is you just told Mr.
Well,
Caltrider.
I told him not all of it because I was fighting with him for another minute further
I'm
down
sorry.
after.
Mr. Caltrider just asked you a question and you gave the answer really closer to 45 seconds. Does that have to do with the contact immediately before the shooting? Is that what you're telling us?
No, that has to do with when I saw the gun, like we just talked about. That doesn't have
I'm
to
sorry,
do with the
you were not
context.
asked how long you saw the gun. You were asked by Mr. Caltrider, and you said that you had contact with these two people for 45 seconds up to a minute and a half. And then you clarified, giving further answer without question, saying closer to 45 seconds. So are we to understand then that that contact that you had with these two people before you were involved in a shooting lasted 45 seconds or thereabouts? I'm trying to get clarification of your answer that you gave this lawyer.
Yeah, about
Thank you.
45
I don't
seconds
have any other
before I
questions.
saw the gun.
Thanks, all I needed to know. Thank you. I don't have any other questions.
Counsel?
That 45 seconds, was that from the beginning to when you were shot? Or is there another timeline? Is that 45 seconds after you were reaching for your phone?
That was 45 seconds from when they came up and when I turned around and saw the gun. You know, it about, yeah, like about 45 seconds later after they came up, I reached for my phone and then turned back around. So
No, it happened pretty quick.
yeah, very quick.
You'd already handed him the shoe?
Oh yeah, showed it to him.
You still have it?
No,
What happened to the shoes?
the shoes I had in my hand when I turned around with my phone. And yeah, then once we started fighting, I dropped the shoes. And then
You asked to handle the shoes?
sorry,
When he said, we're gonna do this, what was your assumption at that point?
what are we gonna do? My assumption when I saw the gun no more than a foot away from me that I was gonna get shot.
Okay.
He said, "What are we gonna do this?" But when you're pointing a gun,
You're assuming they wanted the shoes?
yes.
Thank you.
Okay, Mr. Brown, there is a sequestration order, so you are not to discuss any portions of your testimony with any other witness, okay?
Okay.
Okay, you may be excused. You can call your next witness.
Jonathan Brady.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat, officer. Please, Detective Trooper, if you can state your first and last name and spell both of them.
It's John Brady, it's Jon, last is Brady.
You can proceed, counsel.
Thank you. Detective Brady, where are you employed?
The Michigan State Police.
And how long have you been employed there?
For 6 years.
What is your primary duty?
I'm part of the Lansing Major Crimes Unit. We're embedded with the Lansing Police Department, assisting them with major crimes that occur, specifically violent crime.
Okay, and what do those actual duties entail? What do you do?
So we will be assigned cases that Lansing Road Patrol takes, as long as they fall within that violence category. There are 3 of us troopers that work there, so we're just in the mix with their major crimes detective to investigate violent crime.
So last August 16, 2022, what were you doing?
The 7th, sir.
Okay, and how long had you been assigned to that unit?
Would have been just over a year.
Okay. So on that date of August 16, 2022, did you respond to the location of 1412 West Mount Hope Street, City of Lansing, and County, Michigan?
I did, sir.
And why did you respond to that location?
We had been advised that there was a shooting that had just occurred there.
Okay. And when you first got there, what did you observe?
Numerous patrol cars were there. They were in the process of looking for evidence, pulling video, identifying witnesses, speaking with witnesses.
And what did you do when you got there?
Assisted with all of those things, sir.
Okay. And did you, on that date and time, have any contact with Mason Brown?
Not on that date.
Okay. So your function was you were investigating this shoot?
Yes, sir.
Okay. Did there come a time when you did have contact with Mr. Brown?
There was.
And where was that at?
At the hospital.
And how long after the shooting did you have contact with him?
I'm not positive, sir.
Okay. Was it a week, 2 weeks?
About a week.
A week, okay. But you're not 100% sure.
Correct.
Now, at some point, when you first had contact with him, did you conduct an interview?
I did.
Okay, and after conducting that interview, what was your understanding of why Mr. Brown was at that location?
My understanding is that he was attempting to sell shoes that he had placed an advertisement on Facebook Marketplace for.
Okay, and what was your understanding of, after your interview with him, of what had happened on that day?
The way that it was presented to me was that he had arrived there to try and sell those shoes. Two subjects arrived. It sounded like they were attempting to rob him with a firearm. In the process of that, he attempted to gain control of the firearm, was shot. There was a struggle. He got up, went into the store. The two subjects grabbed him and ran.
Okay. Was a firearm recovered from that location?
No, sir.
Were there any shell casings recovered?
No, sir.
Now, at some point, as you were doing your investigation and interviewing him, how did you personally come to the conclusion that the person said at this table might be involved in that shooting?
Mr. Brown was able to provide me with screenshots of the Facebook profile that had been messaging back and forth with him. Using that name, speaking with analysts that work within the Lansing Police Department, they had notified me that Gavin Komarami is indeed a real person within the city of Lansing that has been known to be associated to guns and violence. Further investigating that, the day of the shooting, we had had contact with two other individuals that had allegedly conducted a robbery across the street earlier in the day. They identified that they had been in the same vehicle as the shooter, ran after the shooting occurred. One of those individuals is stepbrother to Mr. Komarami, which kind of deepened the association.
So with that, kind of putting two and two together.
Yes.
Okay, and at some point in the hospital, I'm assuming when you were doing your investigation, you did do a photo line.
I did, sir. May I touch back just for a moment? With your previous question, during the interview, Mr. Brown had also provided a description. Holding photo of Mr. Komarami, it appeared to be very similar to the description Mr. Brown had provided.
Okay, and that was during the initial interview?
Correct.
And that was more evidence to you?
Yes, sir.
That's an objection to leading.
So at some point, did you?
Objection, assistant
Thank you.
leading.
And based on those things, how did you come to that conclusion?
That furthered my investigation to believe that Mr. Komarami was one and the same person who'd been contacting Mr.
Brown. At some point, there was a photo lineup.
Yes, sir.
And can you explain that a little bit more?
With photo lineups, generally what we do, as long as the subject is not in custody, we'll get 6 photographs of people that look similar. Beginning the lineup, I will read what's called an admonishment form, which just gives them guidelines on the photo lineup itself. Understanding, I asked them if they understand what I had read to them. I write down their response, and then I present the lineup. There is a photo in 6 individual folders, so 6 individual photos in 6 individual folders. The photos do not correspond to the number of the photos, so the photos are numbered, folders are numbered, they are different numbers.
So when you do the initial admonishment, you write in the form also?
Yes.
And why do you write on that form?
I fill out the entirety of the form minus their signature, and that is to document their understanding, their statements, and what they pick.
Now, on this day, did you do that with Mr. Brown?
I did.
You gave him admonishments?
I did.
Okay. At some point, did he identify someone?
He did.
And who was it that he identified?
He identified Mr. Holbrook.
And to your knowledge, you were there that day. Did he hesitate at all?
Remember, he asked to see the folders a few times. I'm not positive the number. His statement was confident, but was that he believes that is the person.
Okay. And you see that individual here in the folder kid was identified?
I do, sir.
And could you point to him, please? Something he was wearing.
He's wearing a navy blue jail jumpsuit.
Record reflect detective is identified.
Any objection to identification?
Without objection, is subject to cross-examination. Thank you.
And when you responded to this location of 1422 West Mount Hope, is that in the city of Lansing?
Yes, sir.
Ingham County?
Yes.
Michigan? Yes. Now, you were here earlier, you heard that there was 2 individuals that had appeared that day.
I did.
Have you managed to identify who the other individual was?
No, sir.
Now, in talking with Mr. Brown, what was your understanding of why a gun was brandished at him?
To rob him at gunpoint.
And after, how many times did you interview Mr. Brown in the hospital? Remember?
There was the initial interview and the photo lineup for the second contact. I believe that was the last contact, other than occasional phone calls back and forth, just updates on the case.
So you haven't interviewed since that time, since they've been here, correct?
Cross-examine.
Thank you. Detective, you had spoken with an analyst by the name of Dyke, D-I-K-E, is that correct?
Yes, sir.
And that had to do with the development of a photo array, correct?
Yes, sir.
One of the things that you told us when Mr. Caltrider was asking you questions has to do with how it is you go about developing a photo array and how it then is comprised. I wanted to make clear, one of the things that you said is we find 6 photos that look similar. That was your quote. Do you recall saying that?
Yes, sir.
Okay. When you say 6 photos that look similar, do you mean 6 photos that look similar to the identification or that is the description that was provided by a witness, similar to that? Is that
No,
what you're
sir.
saying?
No, sir.
You mean similar to a particular person that you've already identified? Is that what you're saying?
Yes, with the idea of a subject, 6 photos that appear similar to that one subject.
Is that the way you always go about the development of a photo array?
Yes, sir.
Finding 6 pictures that look similar to the subject of your investigation, the suspect, correct?
In totality, it would be 5 in addition to the suspect. Yes, sir.
Not, so that we are clear, not 6 people who meet a description that has been provided by a witness. Instead, I want to make sure we're clear, because it's a clarifying question. I want to make sure we're absolutely on the same sheet of music about this, okay? You need to tell us that once you have identified a suspect, a subject, an accused, that's when it is you develop a photo array to try to find 5 others that are similar in appearance to that suspect, correct?
Yes, sir.
And you recall that your first contact with Mr. Brown, the victim in the case, was that at the hospital that day to show the photo array?
No, sir. Those were 2 separate contacts.
You had 2 separate contacts.
Yes, sir.
When was the first contact?
Prior to the photo array.
How much prior to the photo array?
I'm not positive. I believe a day or 2.
And then the photo array at the hospital was then the second time that you had an interview with Mason Brown.
Yes, sir.
You were present when I was examining Mr. Brown a moment ago.
I was.
And I had asked Mr. Brown about how long that contact, when he was in the hospital to talk to you, to be shown the photo array, how long that took. Do you recall how long that interview was?
I apologize. Are you asking the initial interview or the photo lineup?
Well, let's go one by one, and we'll start off with the initial interview. The initial interview that you had with Mason Brown, was that in the hospital?
Yes, sir.
Okay. Was that in his hospital room or elsewhere?
His hospital room.
Okay. And that initial contact, you say, what, some days before the photo array?
Yes, sir.
Okay. That initial contact, how long did that take, roughly?
Between 15 and 30 minutes, I believe.
Were you the only law enforcement officer or law enforcement official present in that interview?
Yes, sir.
Okay. Were there other people present during that interview?
Mr. Brown's mother was present.
Okay. And Mr. Brown's mother was in the room?
Yes.
Okay. Was Mr. Brown's mother in this initial contact in the room with Mr. Brown and you during the entirety of that contact, or don't you recall?
I don't recall if it was the entirety, sir.
Do you recall whether she was there at the beginning of the contact?
Yes.
And she may or may not have left sometime during that short period. Drawing your attention now to the second contact. Same room?
Yes, sir.
Different day.
Yes, sir.
Mr. Brown is in his hospital bed.
Correct.
He has presented then a photo array.
Yes, sir.
How long did the entirety of your contact with Mr. Brown in that room that day take?
Again, I'm not positive, but I do believe it was around 15 minutes or so.
Okay. I'm starting to see a pattern here. Each of those two are about the same period of time. Is that fair?
Yes, sir.
Okay, those two interviews. Now, the second interview, where the photo array was presented, was there anybody else in the room that day during the interview?
I believe Mr. Brown's mother was there again.
In the room?
Yes, sir.
And was she present during the entirety of the interview, or don't you remember?
I believe she was present for the entirety of that contact.
So that last contact, the second of those contacts, she was present during the entirety of it?
I believe so.
Okay. And when she was present during the entirety of it, about how far away was she from Mr. Brown?
She was sitting in a chair in the corner, so it would have been approximately 8 feet.
8 feet. So less distance than between you sitting in the witness box and me standing here behind counsel table now, right?
Yes,
So
sir.
we're about what, 12 feet apart?
I'm not positive, sir.
But closer than you and me.
Yes.
And was the hospital door open or shut? The hospital room door? Or don't you remember?
I don't remember, sir. Generally, I at least close it partially for privacy.
Sure. Was it noisy or quiet there? How would you describe that scene in the second interview?
Quiet.
Okay. Drawing your attention to the first interview, was that noisy or quiet?
Quiet.
Okay. Drawing your attention to the first interview, mother was present at least during part of it, as you say, starting it. How close was she to Mr. Brown physically in that first interview?
She was seated in that same chair, sir, same distance.
Same distance, about 8 feet, no more than 8 feet.
Correct.
Maybe less than 8 feet, is that what you said?
I said approximately.
Approximately 8 feet is good enough for me. Now, on this second interview, no, the first interview, was the first interview video recorded?
I believe so, sir, but I'm not positive.
If it would have been video recorded, you would have presented that to the Office of the Prosecuting Attorney?
Yes, sir.
Okay. Would it be you that directly sends that to the Office of the Prosecuting Attorney, or do you pass that off to somebody else at the post or with other law enforcement agencies?
It would be one of the secretaries that work out at LTD's Detective Bureau.
Okay. So you would have contacted the Detective Bureau and provided that to the Detective Bureau of Lansing Police Department, correct?
I work in it.
Okay,
Yes,
you
sir.
actually work there.
Yes, sir.
But you don't recall whether that first one was video recorded?
No, sir, I don't.
How many contacts did you have with Mr. Brown in total in the investigation? Do you recall?
Not in total, no, sir.
More than the two that we've just been discussing?
And a couple of phone calls that I mentioned to the prosecutor earlier, yes, sir.
Sure.
But those are just case updates, checking on how he's doing with his healing, things of that nature.
After these two
Correct.
interviews that we're discussing now?
Correct.
Because a long time has passed.
Yes, sir. Sure.
So then drawing your attention now to that second interview, was that video recorded?
I don't recall.
Don't recall.
At the time, I was not equipped with a body cam, so generally what I will do is pull up, I've got an Axon mobile app on my department issued phone.
Yes.
And I'll either audio or video record. For photo lineups, I generally try to audio and video record. However, unless propping the phone up, it's difficult to do with handy folders and such, so it may have just been audio recorded.
We're talking about that second interview. Do you think that maybe the first interview may have as well just been audio recorded, not video recorded?
Again, sir, I'm not sure.
But in any event, any recording memorializing these two interviews would have been handed over to a secretary at LPD.
Yes, sir.
Thanks.
I would upload it to evidence.com. Within evidence.com, the secretaries create tapes and then forward that to the prosecutor's office.
You don't recall the specifics of whether you did or didn't, right?
Yes.
You don't recall the specifics of whether or not it was recorded, but you say that you generally would do such a thing.
Yes, sir.
And if you had, that would have been the process.
Correct, sir.
Drawing your attention to that second interview, where you presented the photo array, you reviewed an admonishment form then with Mr. Brown. Fair to say?
Yes.
Now, you heard me asking some questions of Mr. Brown. Are I to understand that you would have read aloud the instructions to Mr. Brown that are on that eyewitness identification admonishment form?
Correct, sir. I do that before every photo line.
Sure. And when you do that, you told us on direct examination that you fill out then the fill in the blank portion as best you can, except for the signature line, right?
The signature, and if they're able to write their own name. Yes, sir.
Sure. So down at where it says witness statement, there'd be a signature then of the witness and a printing then of the witness's name, and then a signature on the line that reads signature of witness.
Correct, sir.
And that signature paragraph is really an affirmation or an acknowledgement that the person who is signing understands what has been presented to him, right?
Yes.
And has reviewed it, correct?
Yes.
And that it's accurately accurately reflects what it is the witness said.
Yes, sir.
Okay. It actually reads, I blank affirm that I read or was read the instructions above, that I understand the instructions, and that the statement written by the law enforcement official accurately reflects what I said. I understand that I should not talk to other people about the photos or tell them which photo I picked, if any. Correct?
Correct.
Okay, fine. Now, you don't recall necessarily how many contacts you've had since that second interview with Mr. Brown, but do you have a general idea as to how many? Like a vague number, or no?
Probably between 4 and 5 phone calls, sir. Just most of them brief.
Sure. No more in-person contact.
Correct.
Okay. Those are not recorded in any way other than the notes that you keep, correct?
Correct, sir.
And reports that you prepare.
Correct.
Drawing your attention to that business of notes that you keep and reports that you prepare. When you have concluded an interview of a witness, is it your practice then to, or during that, either concurrent with the taking of the interview, or immediately thereafter, is your practice then to memorialize that in some way in writing?
Yes, sir.
Okay, is that something that you refer to or know as field notes?
No, sir. Generally, if I'm interviewing somebody, I like to engage with that person.
Yes.
So I don't take a lot of notes beyond just general, this is my name, here's where I live, here's how to contact me.
Sure.
And then from there, I want to focus on what they're saying to me so that I can better engage and ask clarifying questions.
So you can actively listen.
Correct.
Ask more probing questions resulting from the answers that have been provided to you.
Indeed.
Okay. So that would be a reason why it is audio or video recording would be something that would be handy for you for later note taking, correct?
Correct, sir.
Okay. So you're not sitting down jotting down a whole bunch of page after page of notes while you're interviewing somebody, you're trying to engage them.
I try my best to.
And do you then prepare some sort of handwritten note after you've completed the interview or no?
No handwritten notes, sir. I'll go back with the recording that I have and cite the police report.
Go straight to a police report from your recording.
Yes.
And is that recording then destroyed thereafter?
No, sir. That would be what we spoke of earlier.
Oh,
that was
would be
uploaded to evidence.com.
That would be the recording thing that winds up being uploaded to evidence.com.
Yes, sir. I'm the same.
Now we're on the same shit. So thank you. Just one moment, Your Honor.
I don't have any other questions of this witness. Thank you, Your Honor.
You direct?
So how many, in your career, how many formal lineups?
50 probably.
This was just, so you probably have a routine that you follow at the time. Is that
Guess I
correct?
have to object to the leading.
Do you have a routine that you follow at the time?
Yes, sir. I follow the same practice every time.
On this occasion, was there anything unusual?
No, sir.
Mr. Brown was very clear about that.
Object to the
We
leading.
can't hear.
How clear was Mr. Brown about it?
During the lineup, sir, or today? He's pretty good.
No further questions.
Thank you. You can be excused from the stand. You can call your next witness.
You have no more witnesses.
Thank you. Is the defense calling witnesses today?
No, Your Honor. Thank you.
You can proceed to argument.
Thank you, Your Honor. We had two witnesses take the stand today. One was the victim, Mr. Brown. The other was detective investigating the case. Mr. Brown testified he placed a pair of shoes for sale on Facebook Marketplace, received a response to that from and I know I'm going to get his name wrong, Gavin Komarami. There was an agreement they would meet at Quality Dairy. That's located at 1412 West Mount Hope in the city of Lansing, Union County, Michigan. And Mr. Brown indicated he chose that place because it was a public forum, so there would be other people around at that time. He then proceeded to that location. I believe he said about 10 minutes later, two individuals came up to him, one of them being the defendant, who he was very clear in identifying who he was and what he was wearing. Black hoodie that day. Also, that he sees him in the courtroom today wearing a blue jumpsuit. He indicated he turned around to, he showed the shoe, one shoe, turned around to his car to get a, I believe he said a receipt of some kind, a e-receipt. When he turned around, he indicated that the defendant here was holding a gun with his right hand pointed at his lower, I guess you'd call that torso area. And then the words were spoken, "Are we going to do this?" He understood that to mean that he was being robbed at that point. Sounds like he indicated he tried to push the gun away. There was a gun went off one time. He was shot in this area of his lower abdomen, stomach area. I think after that, indicated he reached out and then did get the gun. There was a struggle. He did manage to get the gun. He fell on top of it. He then indicated that the two individuals, one of them being Mr. Komarami, then were able to retrieve that gun from him, get him off that gun, retrieve it, and they fled the scene. He then indicated he managed to get inside the store where he requested the time when called and did respond to that location. At this time, the defendant is charged with 3 counts, one being assault with intent to rob while armed, one being carrying a concealed weapon, the other being weapons, carrying a dangerous weapon with unlawful intent. I would indicate from the jury instructions for those charges, and I'm going to ask for some additional charges to Your Honor. So I will start with the ones that are already charged because that's probably the easiest. First, the defendant, what we would have to prove, and understanding that the proof that is needed today is probable cause, not beyond a reasonable doubt, just enough to sustain the charges. First, the defendant assaulted Mr. Brown. There are 2 ways to commit an assault. Either the defendant must have attempted or threatened to do immediate injury to Mr. Brown and was able to do so, or the defendant must have committed an act that would cause a reasonable person to fear or apprehend an immediate injury. Clearly, when Mr. Brown turned around and the gun was pointed at him, that would meet the prong of the test that said he was put in reasonable apprehension. In fact, he did indicate he was scared, caused him to try and knock the gun out of the way. And then there was an actual injury because the gun was fired and was shot in the lower part of the abdomen. Second, that at the time of this assault, defendant was armed. Clearly, I think there was clear testimony today about the fact that defendant was armed with a firearm that day, which was pointed at him. A weapon. So I believe we meet all of the prongs. Second, at the time of the assault, defendant was armed with obviously gun. So I'm going to ask you to bind over on that charge. Fourth, it indicates at the time of the assault, the defendant intended to commit an armed robbery. It was obviously Mr. Brown's understanding that he was being robbed at that time. Robbery occurs when a person assaults someone else, takes money or property from him or her in his presence, or intending to take it from that person. I think Mr. Brown indicated the intent was to take the shoes, and that's where the gun was drawn. There must only be proof, and this is for the jury for the trial. So on that prong that I'm going to ask you to bind over on the initial charge. There's also a second charge carrying a concealed weapon. We must prove here the defendant knowingly carried a pistol. Does not matter why the defendant was carrying the pistol, but to be guilty or to have probable cause defendant. I would indicate there was a probable cause that he was carrying a pistol at that time. I believe Mr. Brown testified that he did see the pistol. Definition of pistol obviously is contained in criminal jury instructions. I would indicate that clearly this was a pistol weapon that was used and discharged. Mr. Brown also testified that when the two individuals initially walked up, he did not see the weapon. And it was not until he had reached into his car to grab his phone and turn around that he saw the weapon. I would indicate that that would be evidence that the pistol was being carried up to that point, hidden until the point it was pulled and pointed at Mr. Brown. Also, there's a third charge, carrying dangerous weapons with unlawful intent. Clearly, a pistol is a very dangerous weapon. Unlawful intent here is that we're there to commit a robbery at that point. And take the shoes from Mr. Brown. So I would ask you to bind over on that charge. In terms of additional charges, I'm going to ask for a second. Going to ask for an additional charge under MCL 755-29A. That would be armed robbery causing serious injury. And I will indicate to meet that burden, we would have to show that the defendant intended to commit a larceny at that time, was armed with a weapon, and put this person in reasonable fear of an armed robbery and that a serious injury did occur. Obviously, the gun went off. Mr. Brown was shot in the lower abdomen, so I think we meet the serious injury. The property being taken at that point was the shoes. There was a use of violent force against Mr. Brown. Obviously, he was shot, and it did put him in fear and apprehension. At that time, the defendant did possess a dangerous weapon, that being gun. He described it as a black handgun, so he was familiar with weapons. It was not a pistol. I think he described it as, or not a revolver, but described that as a pistol. And the defendant possessed article and used that in fashion that made a reasonable person to believe the article was a dangerous weapon. Obviously, he believed it was a dangerous weapon. He reached out to push the gun away from him. So I'm going to ask you to add that additional charge. Also, we would ask for an additional charge of just plain robbery. Obviously, the defendant's charged here with attempt to commit an armed robbery or a robbery while armed. I think that in this place, the defendant did use force or violence against Mr. Brown, or put him in Mr. Brown in some type of reasonable fear or apprehension of a robbery. Second, the defendant did so while he was in the course of committing a larceny. Here, the larceny was the theft of the shoes. The larceny means the taking movement of someone else's property and money with the intent to take it from that person permanently. In the course of the larceny includes acts that occur in an attempt or to commit a larceny, or during the commission of a larceny, or in flight from the commission of a larceny. Third, the defendant here was present or that the victim was present while the defendant was in the course of committing that act. I think all of those apply. Finally, I would ask for one additional charge, and I believe that would be under MCL 227BA, indicate that at the time a felony committed, the felony being the armed robbery, that the defendant was armed with a weapon. I think it was very clear that Mr. Brown described that gun in his testimony, so I would ask you to bind over on possession of a firearm during the commission of a felony. Understanding probable cause.
Okay, so requesting an account be added for armed robbery causing serious injury, and then account added for robbery.
Armed robbery resulting in serious bodily injury.
Correct. I said that one. That was the first one you requested.
That was the first one I requested.
The first one. The second one you requested was
just robbery.
Just robbery, and then the third one you're requesting is possession of a firearm and the commission of a felony.
Correct.
Okay. Mr. Watson.
Well, certainly, Your Honor, the people had expressed at the time of the probable cause conference their insistence upon conducting the examination. Certainly as well, considering the fact that this fact pattern is from August of 2022, people had the opportunity and could have, as I should have, screened on the various counts that they intended to charge in the first place. It's not as if somehow the development of the testimony of this witness, the brief testimony of this witness and of this trooper somehow developed into now 3 counts, 3 separate crimes as it relates to one event under the idea of robbery armed. The matter started off as assault with intent to rob while armed. Mr. Coltrider, I think, simply misspoke, because one of the things he says is his argument is that this defendant is charged with attempt. He's not charged with attempt at all, to my knowledge, according to the complaint. Instead, his original charge, count 1, was assault with intent to rob while armed. Carrying concealed weapon is count 2, and carrying with unlawful intent is count 3. I would ask that Your Honor look with great scrutiny at the testimony provided to ferret out whether or not there is indeed probable cause to believe that each of these crimes, in addition to the additional request of the people, whether that burden has been met as is necessary. Thank you very much, Your Honor.
Mr. Coltrider.
Thank you, Your Honor. Mr. Watson is right. That was in this presentation by me. It's not attempt, it's actually assault with intent of armed robbery. Obviously, this wasn't charged with the other charges initially. We're here for the preliminary exam. We see what the evidence presents. At this time, we would ask for those additional charges.
Yes, Mr. Komarami, Your Honor, could have been arraigned on these charges. It seems reasonable that people would anticipate what the testimony may reveal, considering the fact that they all lie in robbery armed. All 3 counts as it relates to the word robbery. All things reasonably have been foreseen at the time of screening prior to Mr. Komarami being arraigned. Thank you.
Mr. Komarami, today's the date and the time that was set for a preliminary examination, which we are concluding at this time. The purpose of the preliminary examination is to require the prosecution to meet their burden. So they have to establish at this hearing whether or not they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. So this is not a trial. It's not beyond a reasonable doubt that this is the burden that they need to meet. It's just more than mere suspicion that a crime was committed. It's a relatively low burden. And the court will be the sole determiner of any of the credibility of any other witnesses at the time of the examination. And then the burden is flexible as it relates to the evidence that's presented here today, but we're using a common sense standard. I have account 1 here, assault with intent to rob while armed. Account 2, weapons carrying concealed, and account 3, weapons dangerous, weapon carrying with unlawful intent. In order to prove this at trial, and I think Mr. Cartwriter went through the elements, so I won't rehash them again. The people at the time of trial will need to prove those elements right beyond a reasonable doubt. assault with intent to rob while armed. We have the testimony today of witness Mason Brown. He testified that on August 16, 2022, he was the area of the Quality Dairy on the corner of MLK and Mount Hope, which we later determined was at 1412 West Mount Hope, when the detective trooper testified. That's in the city of Lansing, Ingham County, state of Michigan, making venue before this court appropriate, that he reported to this address to meet an individual that was identified via Facebook as a Gavin Komarami. That he waited for a few minutes, that he received a message, and that the defendant, the person he identified as the defendant, that is, made his way to that location, that he arrived with another individual, and that upon arriving, the victim showed one of the shoes. I think he said he was selling Yeezy 700s on Facebook Marketplace. He showed one of the shoes to the individuals. He indicated that the shoe was showed to, I think on his direct examination, he says that he handed the shoe off to the person he identified as the defendant, but I think he was corrected on cross and indicated that he had never handed the shoe off. He didn't hand the shoe off, but that he showed it and he kept the other shoe, and that he usually only shares one shoe, or shows one shoe, that is, as a way or a mechanism to show or keep him from being robbed or ripped off. Nonetheless, he testified that he then reached into his vehicle or returned to his vehicle. Not clear if the door was open or not, but he has long arms. He was able to get his or retrieve his phone because he wanted to show a receipt. When he turned around, he indicated that he saw a firearm pointed at him, and that the person he identified as the defendant was pointing the firearm. He demonstrated here in court during his cross-examination how that firearm, or how he perceived that firearm to be demonstrated. He described what he believed the firearm to look like. It was a black handgun. He was sure it was not a revolver. He described it as medium size because he wasn't comfortable with describing it as either fat or thin. He said that he was shot in the stomach area, that there was a scuffle that ensued as he tried to disarm or take the firearm from the person he identified as the defendant. He was later transported to the hospital. He did have contact with law enforcement, mainly Detective Trooper Brady, and that he did complete a visual lineup, and he identified the person number 3 as the person who was the subject who shot him in an attempt to rob and cause injury. So in this count 1, the elements that would need to be established at the time of trial, again, would be first that the defendant assaulted Mr. Brown. The 2 ways to commit an assault include either the defendant must have attempted to threaten to do immediate injury to Mr. Brown and was able to do so, or that the defendant must have committed an act that would cause a reasonable person to fear or apprehend an immediate injury. Mr. Brown testified that when he turned around, that the defendant was holding a gun in his direction and stated something to the effect of, "What are you gonna do?" Mr. Brown testified that he perceived that to mean that he was being robbed for the shoes and he thought he was going to be shot. I think a reasonable person turning around under any circumstances, but particularly when making a transaction and they turn around and the person they don't know is pointing a firearm at them and says something to the effect of, "What do you want to do?" or what are you going to do? Would fear reasonable apprehension of immediate injury or harm. And so I think that element is satisfied at least to a probable cause standard. Second element would be that at the time of the assault, the defendant was armed. Again, we had testimony that the defendant was armed with a firearm, which would be described as a dangerous weapon capable of causing death or serious injury. Third, that at the time the assault, the defendant intended to commit a robbery. Robbery occurs when a person assaults someone else and takes money or property from him or her in their presence, intending to take it from them or the person personally. It is not necessary that at the time of the crime that was committed or that the defendant had actually taken any money or property. However, there must be proof beyond a reasonable doubt that at the time of the assault, the defendant intended to commit a robbery. I think it can be assumed based on the evidence and testimony here that they were meeting up for a transaction when showed the objects that was to be for sale, and the victim turns around, or the alleged victim turns around, sees a firearm, and there's a statement of what are you going to do. I think that it's reasonable to assume that there was an intent to rob or commit a robbery at that time, at least to a probable cause standard. So count one will be bound over as charged. Count two, weapons carrying concealed. Requires that the people prove beyond a reasonable doubt first that the defendant knowingly carried a pistol. It does not matter why the defendant was carrying the pistol, but to be guilty of the crime, the defendant must have known he was carrying a pistol. Second, that the pistol was concealed on or about the person of the defendant. Complete invisibility is not required. A pistol is concealed if it cannot easily be seen by those who come into ordinary contact with the defendant. The victim testified that when they arrived, he showed a shoe to Mr. Komarami. The victim did not testify that he could clearly see at the time a firearm on the defendant. And then as to the element that needs to be met at the time of count two, the first element, the testimony was that when he turned around, the firearm was being pointed at him by the defendant. The defendant would have known if it was in his firearm, in fact, that he was carrying a pistol. And as it relates to whether or not we're talking about a pistol versus a revolver, he was adamant that it was a black handgun, medium in size. And so as to count two, weapons carrying concealed, the court satisfied that there is probable cause sufficient to bind over. Count three, weapons dangerous, weapon carrying with unlawful intent. Requires the people to prove beyond a reasonable doubt first that the defendant went armed with, in this case, a pistol, and second, at the time that the defendant intended to use the pistol or the weapon unlawfully against someone else. And so the allegation is that he arrived with a black medium-sized pistol with the intent to rob the victim of some Yeezy 700s. The people are asking to add an additional count of armed robbery causing serious injury. I think we've already established on the record elements sufficient to a probable cause standard as to armed robbery. The defendant testified, however, that he did sustain some injury to his stomach and possible, I think, some other internal injury. Nonetheless, the court is satisfied that there is sufficient probable cause to add count 4 of armed robbery causing serious injury. The people are asking to add a count 5 of robbery. I'm not 100% sure why account 5 of robbery would be necessary versus the armed robbery. Can you give me some clarification why you want account 5 of robbery?
Well, when this goes to trial, Your Honor, they decide to convict the lesser offense of robbery. As opposed to
So in the alternative, you mean? Okay, so the people are requesting to add account 5 of robbery in the alternative of armed robbery for the purposes of trial. And again, the elements for robbery would be for the people to prove beyond a reasonable doubt that the defendant used force or violence against or assaulted or put someone in fear, that in this case, the someone being Mr. Mason Brown. Second, that the defendant did so while he was in the course of committing a larceny. A larceny is the taking and movement of someone else's property or money with the intent to take it away from that person permanently. Based on the testimony and evidence submitted today, the court is satisfied that count 5 can be added and bound over in the alternative of count 1. Okay, count, or the people are requesting there to be count 6 of firearm and use of a firearm and commission of a felony. And the testimony here today was that the defendant committed the acts allegedly of assault with intent to rob while armed, carrying concealed weapons, dangerous weapon, carrying with unlawful intent, and now added counts 4 of armed robbery causing serious injury and the alternative account 5 robbery, and that he did so while using a firearm to commit or allegedly commit those actions. The court is satisfied as to count 6, and that will be added and bound over with counts 1 through 5. Bind over date will be August 9th. You do not need to appear in court on August 9th, Mr. Komarami. That's the date that the circuit court will get the file from the district court. Your next court date will be a pretrial, and your attorney will be made aware of that date, okay? Do you have any questions for the court today?
No. I think from the people here.
Bond was set at 75,000 cash surety that will continue with a no contact order as to Mason Brown. Any additional matters for the record?
When Your Honor inquired of the prosecuting official reasoning as to the request for count 5, the response that was provided by Mr. Calpower had to do with lesser included. I would note that the armed robbery was certainly not a lesser included armed robbery causing serious bodily injury. Instead, it's a sentence enhancement. I just wanted to make sure that we are clear on that.
You said robbery would be?
Robbery causing serious injury is a sentence enhancement. It is not an offense for which there is a lesser included of armed robbery. So that's my position. I just wanted to thank Your Honor. And if Your Honor rethinks the issue of then robbery armed count 5, if that caused Your Honor to rethink that, that would be great. If not, my position, of course, is that every one of the counts related, well, frankly, every one of the counts that the people have asked for here at the examination are things that could reasonably have been anticipated at the time of the initial screening for the purposes of charging and arraignment. Thank you very much.
Thank you. And did you want to address the robbery concern?
Well, Your Honor, I would like just to answer for distinct as.
Okay, sounds good. I will be found over as stated on the record. Any additional matters?
Nothing from the people.
Nothing further from the defense. Thank you, Your Honor.
Thank you. Have a good one.
Today, let them know. Yes.
Yeah, that's what I was hoping. It's like, because you can check.
Thank you, Your Honor.
Thank you. on the record in the matter of the people of the state of Michigan versus Robert Holbrook, file number 23-01512, council appearance.
Your Honor, Dale Culture appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Robert Holbrook, who is present standing to my right. Mr. Holbrook, could you report?
Okay, Mr. Holbrook, you were scheduled to have a preliminary examination today, and my understanding is that you had some issues with your transportation.
Yes, Your Honor, sorry about that.
Okay, so does he still want to have his exam?
Your Honor, it's my understanding that the state's going to dismiss the case.
Oh, okay, looks like they did not have necessary witnesses.
Correct, Your Honor, we do have officers here, but we do not have victims, so the trial's consent.
Okay, so this matter will be dismissed without prejudice. That means that the people do have the right to reissue the charge if the necessary witness appears and is ready to proceed with this case, okay? We'll get you a copy of your dismissal and you'll be all set.
Thank you, Your Honor.
No problem. Thank you.